Good morning, everybody. How y'all doing? Good morning. Good morning. How y'all doing today? Good morning. Hello, how you doing? Good morning, everyone. We're going to see if the jury comes back today. Going to see what happens. Okay. See what happens. Today. Good morning. So no jury again today. So today's probably going to be another boring day. We should be able to get started soon. I'm going to go make my coffee, everybody. Good morning, good morning, good morning. Happy Friday. The jury is out because there's a sick juror. The jury is out. We can definitely watch the Fani hearing today. We definitely can. Let's go. Good morning. Good morning.
do not have our jury back yet. So I guess it'll be Monday before we continue with witness testimony. However, I'm hopeful that we can get through some further evidentiary issues today. And I know we can at least finish going through the last 12 pages or so of the exhibit and witness list, and beyond that, I don't know whether anybody's ready with any of the other issues that we were going to get to at some point or not. So y'all just kind of have to let me know. Oh, sorry, y'all. When they tell me we're ready, and that everybody's here, I guess I should stop and actually look. Okay, well. Didn't know you weren't here. Came in because they said everybody's ready. All right, so if y'all can give me an assessment of what we're ready to discuss, and if you think it's going to carry us through the full day or not.
Good morning, Your Honor. Simone
Morning.
Hilton for the state. Given the instructions that we received on Wednesday, we're working through reducing the wiretap. We're working through the research on the case law that's due on Monday.
Okay.
But we are ready to go through the exhibits for the remaining witnesses from 61 all the way to the end. I believe that Dropbox was served approximately 2 weeks ago. I'll pull up the exact date in which it was served. And so we're ready to move forward. I don't know if that will carry us through the entirety of the day, but it is about 40-something witnesses.
Okay.
That we could go.
All right. And on the defense side, anybody have anything in particular that you're thinking today would be a good day to discuss?
Myself and Attorney Steele talked about this last night, and the only thing that we were thinking about was the wiretap, but it sounds like we're going to wait for the state to try to pare it down before we tackle that. So I think that's all we have.
Okay.
Salvo court is open. I know I challenged the jail call of Mr. And by the way, good morning, Your Honor. Good morning, everyone. Arnold on January 10th, 2015. And there's some, I believe, on the next day that the state may seek to admit. And a lot of it is, in my opinion, irrelevant. I don't know if we're going to listen to those calls for this honorable court to pare down, or if the state should get together. But there's a lot of talk about food and girls and things like that. In addition, and I'm not saying, you were interested, and I didn't say anything about Miss Morton being supposedly at the Texaco on the recording, and you said, oh, that may be enough for a conspiracy. I don't believe it is. I'd like to talk about that. But if you admit that, does your honorable court understand OCGA 24-1-106? So if that recording comes in, well, then I'm asking for guidance. So if that recording comes in, and if Miss Morton is not a witness, the state spoke with her, they put it before a grand jury, and they had a court reporter, and they did audio recordings with her at her probation officer's office. And under the rule of completeness, it is, you know, on that recording, it may be something that the state thinks is interesting to the jury, but it would be totally misleading if they're saying Mr. Williams is at that McDonald's. So my point is, another recording, another transcript, sworn testimony for this uncalled witness, I would seek to introduce through cross-examination of Mr. Sprinkle. He was at both of those places, and I believe that I would be able to get it in under 24-1-106. So I say that just because that's another issue if you want to do that.
Okay, so the other recording is an entirely different time?
Date, time, location, absolutely. And there's two, like I said, one's grand jury sworn testimony and one's probation officer.
So my understanding of 106 is that it's if a part of one recording comes in, then in fairness, if the other party seeks to introduce the redacted or unintroduced part of the same recording in order for it to give a complete picture, that can occur. But I don't know that that means an entirely separate recording from an entirely separate date with entirely separate people communicating. So if you have law that indicates that, then I'll consider that.
So it's OCGA 24-1-106, I'm quoting. When a writing or recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any other part or any other writing, recorded statement, which in fairness should be considered contemporaneously.
All right.
So if I'm reading that wrong, I apologize,
And
but
if those are the words, then you might have a good argument.
okay. I just want to bring that up since you're
Okay.
asking for issues.
All right. And is the state, I haven't heard the contents of that phone call yet anyway.
You're right. I think that we can discuss with Mr. Steele the parts that he's discussing. I believe that we can come to an agreement on what is not, the parts that are not relevant in that phone call. And if we can't come to an agreement, we can bring it to the court. But I think it's something we can.
Okay, well, I don't know that his objection is simply relevance. I think he has a relevance objection to parts of it, but he's saying other parts of it, if there is something potentially misleading and there are other recordings that establish, that, it actually mean what it sounds like it means, then he would seek to introduce those other things that would clarify that.
Yeah, so my understanding, if it's the call that I am thinking of, and if it's the call that was discussed yesterday, and I would need to listen to it again, I believe there's an inference as to Mr. Kendrick. I believe that in that call, and if it's the same call, and I'll need to just confirm that Mr. Bradford or Mr. Arnold calls Mr. Bradford while he's in custody. And at a portion, Mr. Bradford is with Bushi. Mr. Arnold asked Mr. Bradford, where is Yak? And Mr. Arnold responds, we're waiting for him. Mr. Bradford or Bushi, Ms. Morton, says we're waiting for him. And they were talking about Yak Gotti. So I don't know. I will need to listen again and see if there's any other reference to Mr. Williams, and I will listen again to make sure. But my understanding is, and if this is the call that that was discussed yesterday, then I need to listen again and see if there's a reference to Mr. Williams and being at the McDonald's, because my understanding is of the call is a little different, which is the only reference is Mr.
Then y'all just
Kendrick.
Take another listen to it and get together on that. All right, and y'all can present if you resolve, great. If not, we'll present whatever the issue is after y'all both had an opportunity to listen to that, and if necessary, whatever part of the grand jury recording might then be relevant.
And excuse me, Your Honor, and I apologize, since I wasn't here yesterday. Are we still litigating whether that call comes in?
Yes, we haven't made any kind of determination about that.
Okay,
In fact, Mr. Howell, I think, asked that we hold off until you were present. So we just sort of, mapped out broadly what the issues might be, but we haven't listened to the call or made any kind of
Okay.
determinations about it.
thank you, Your
And it
Honor.
sounds like we'll hold off on that for a little while anyway, and it may or may not end up being necessary to litigate anything about
Thank you.
it. Okay. All right, so do we think I guess the Dropbox with the evidence is on witnesses 31 through 60 is that going to track sort of this witness chart that we were going through yesterday?
It should be, Your Honor. I thought, if my memory served me correctly, that we finished up to 60. We had
I
completed
thought
60.
we had two.
We did. We completed 60 and we were at the
Yeah.
final group. Yes,
Yes.
Your Honor.
Okay, so, all right, so we were kind of using this chart yesterday. So to determine, okay, are there things that we need to litigate? So if we
Yes,
want
Your
to
Honor.
just continue along with that, and then if there are things we need to litigate, then we'll jump to that Dropbox link and pull up that evidence. Is that the suggestion?
Yes, Your Honor. And I'm searching to see the date that we sent the Dropbox link so everyone can find it.
No, I'm sorry. That's the one
No.
that you guys added.
Yeah, I think it might be August 27th, but I just wanna- Yes, it's going to be on August 20. Oh, yeah, it should be August 26th, and we sent it around 11:42 p.m. And if it's not, let me make sure. Okay, I don't think that's the right one. You're on it.
One I have is
Evinger videos is what the reline is? Is that what you said?
Of course it's on.
Oh, yeah, she was saying she didn't think it was the right one either. This thing is to just resend it.
created. I can't find the email, but I'm just gonna resend the link right now.
I, yeah, if you don't mind.
Okay. I just sent it, so it should be coming soon. Yes, yes.
Ms. Hilton, it looks like it needs a password and that wasn't in what you sent me just now.
Okay, hold on.
I don't think it's in what you sent anybody. Because Ms. Persfield just forwarded what you sent. So I think we'll all need that as well.
All right, hold on, my Dropbox link savviness isn't.
Good morning, guys. There is no jury today. Good morning.
Okay, I'm going to resend it. I found the email. The email was sent on the 30th. I believe the link will be in this email that I'm about to
Okay.
forward to everyone.
And the password.
And the password.
Okay. All right, everybody's about to get a different email that'll have the password also.
I just forwarded you.
Okay, this starts with Adrian Ansart.
Yes, Your Honor.
Okay. Is everybody in there now? Does everybody have the Dropbox link up? Okay. All right, so number 52 is Miss Ann Sard. She's going to be the records custodian for the Instagram records for a couple of the co-defendants. Any issues we need to litigate with her?
And Your Honor, I'll say 52 and 53, we already litigated, and the reason why it's in this folder is to be consistent with this document. So we looked at Sergeant Matthew John Pierre's folder
Okay, great.
as well as Ansar's
All
folder.
right. So moving on to 54. Anything?
So we're just getting caught up.
So I can confirm we're all on the same, we're looking at social media, what pictures of Mr. B?
No, because 52 and 53 are already folders that we've already gone through last week. So Sergeant Matthew John Pierre, these are the same videos we talked about, I think, earlier this week as well, where we went through the timestamps of the video. So we already talked through this folder. It's a duplicate folder. So we really should be on 54.
All right, so if everybody will open folder 54 for Officer Rogers and tell me whether there are any issues in the evidence contained within that folder.
Your Honor,
Yes.
may I ask the purpose of the medical records? I think there are pages 1 through 108, I believe, or maybe 5 through 108.
Yeah, we might not get into the medical records. We probably won't get into the medical records, but because they are Officer Rogers records, we included them in the folder. We believe his testimony will be sufficient. We don't intend on calling a doctor. However, we just included it within the folder because they're related to Officer Rogers.
Okay, so those, you probably wouldn't tender those anyway, and if you did, they most likely would not go out to the jury.
Yes, Your
and
Honor.
Probably wouldn't be displayed. Okay, is that sufficient?
Okay, and looks like there's probably about 3 hours of body cam. My understanding of the body cam is at least a portion of it contains the actual altercation between Officer Rogers and Mr. Eppinger, which I understand, but is there any other purpose of the body cam that they would be seeking to introduce in this case, or the state would be introducing in this case?
So the portion of the various body cams that the state intends to introduce, one, yes, the interaction between Officer Rogers and Mr. Eppinger, then portion of the interaction between Sergeant Johnson and Mr. Eppinger, and then a portion of the apprehension of Mr. Eppinger. But that probably in total is less than an hour. I would think if it totals 30 minutes, but it's probably only about an hour total of all the different body cams in this case.
At some point, can we just get the times that you're seeking to introduce?
Do you have those now?
I don't have them now, but it's quickly for me to get them. If not by the end of the day, I can definitely get it to them by early next week. The various timestamps and the various body cam videos.
Okay. All right, so you'll get them the timestamps so that they'll know if they feel like that's the reasonable and relevant portions or something more than that. All right. And then I guess the same with whatever the other medical record is.
Yes, Your Honor.
All right.
And if we're moving on to the next folder, Sergeant Erin Brown, she is only bringing in Officer Rogers' body cam as a custodian of records, given
Okay.
the trauma of the incident. Officer Rogers, we're not going to bring the video in through Officer Rogers, but through Sergeant Brown. So that's what her folder would entail,
Okay.
which would be the body cam video.
All right. So on to Sergeant Johnson then. What all is this?
So that is the overall surveillance video of the entirety of the interaction with Mr. Eppinger and both Officer Rogers and Sergeant Johnson that's not captured on body cam video.
All right. And so we'd only be watching whatever parts we wouldn't have otherwise seen.
Yes, Your Honor, and we'll get those timestamps as well.
All right. McKesey, is that how you say that person's name? McKessie.
And he falls into the same category with the body cam. He's that last portion that I referenced, and so we'll get the relevant timestamps.
I'm confused. What's he doing that?
So he was a part of the apprehension team. So once Officer Rogers was shot, he was taken to the hospital by other officers.
Yeah.
And so later when they went to get Mr. Eppinger, McKessie's involved in that portion of the video.
So under the Rogers folder, the part that you said was the apprehension of Eppinger, that's not actually, whose body cam is that, or what is that? Or is it the same thing, just under two separate witnesses? I mean, you had mentioned with the Rogers file, the interaction with Eppinger, Johnson's interaction with Eppinger, and then the apprehension of Eppinger. So is that actually going to be coming in through McKessie, the apprehension part?
The apprehension part is coming through McKessie, but what we've done is all the body cams are in one evidence.com folder. And so we...
All right, so but that's the same thing in two different
different
places.
folders.
Okay.
Yes, Your Honor.
All right, so you'll get us those timestamps. All right, then we move to Captain Wofford. And what's this about?
So Captain Wofford, yes, okay. That is the surveillance video for the stabbing of Mr. Rayshawn Bennett. And it shows the entirety of that interaction between Mr. Myrick and Mr. Bennett.
When you say surveillance, I'm seeing, correct me if I'm wrong, Captain Walker is the gentleman who came in. Captain Wofford is a gentleman who came into the pod after the altercation and was wearing the body cam.
Yes, but he's also able to serve as the custodian of the Pelco system, which is the jail surveillance system.
Okay, but the in this folder, the Axon stuff, that's Captain Wofford's.
Yes.
Okay, and so we'll make sure that you will make sure that this is not cumulative.
Yes, Your Honor, because the body cam video is only once the stabbing occurred. The
Okay.
surveillance shows everything leading up to the stabbing.
Okay.
And Your Honor,
Mm-hmm.
my other concern now, I'm going off of my prior review of this.
Mm-hmm.
My my recollection and belief is that Mr. Bennett on these body cams doesn't say a whole lot, but at this point, my understanding certainly is Mr. Bennett is not testifying in this case. So I just think we have to, and I'm going to ask the state to make sure that anything that they seek to introduce to these body cams does not contain testimonial statements concerning the events that had occurred.
Yes, I think what's on the video, we would argue would be excited utterances because it's a lot of once he was stabbed. I don't believe he made any statements to the police regarding who did it. And so our intentions would not be to introduce anything like that. It'll be primarily once he's apprehended, more of the excited utterances and present sense impression of Mr. Bennett at that time.
All right, well, so I guess you need to make sure of that.
Right. I don't.
And it may be that you think it's one thing and they think it's another. So we might need a little more specificity about what's coming in.
I don't
discuss it.
recall him saying too much, but he was definitely being spoken to and asked questions by law enforcement about what happened. So anything he said from our stance would be testimonial. But I don't recall at this time him making any statements. But
Your Honor, we can look at it and talk about it and see if we can come to an agreement. And if not, we can bring it to the court's attention. But I think it's something that we could resolve short of having to have the court intervention.
Okay. I mean, these things like the disciplinary hearing dispositions and things, those are just in there because maybe somebody might need to refresh their recollection about them or something. I mean,
Yes, Your Honor, these aren't things we intend to introduce, especially if Mr. Bennett is not going to testify. If he ends up, then that'll be a different story for a different day. But
all right, well, the defense, y'all have had this evidence in this format under these witness folders for a while now. So it's also incumbent upon y'all to take a look at it and be prepared to say, well, there's, absolutely no way evidentially that XYZ should come in if that's what you think. But yeah, it would be helpful for us to not have to litigate stuff that the state doesn't really intend to put in to.
Your Honor, I would.
Yeah.
So there's a surveillance video, as you know, and then a body camera, the law enforcement comes in thereafter. Anything outside of that at this point, I would be objecting to. It's my strong memory that Mr. Bennett did not make any statements to law enforcement. If he did, it's confrontation clause if he doesn't testify. So anything other than those two items, I would be objecting, if that helps.
All right, so Miss Hilton, take a look, and if you think there are some statements that are shown on any of that body cam of Mr. Bennett that you believe come in as, a cited utterance or present sense impression, then, and you intend to introduce them, then you can maybe call that to our attention and we can make a decision on that. Okay. Where are we now? All right, have we already? Okay. So if the defense, y'all kind of seem to be, I don't know if y'all are, I don't want us to be doing a real-time evaluation of this amount of evidence. If we're ready to litigate these things, great. But if we're not, y'all just let me know that.
I've reviewed the wiretap from Mr. Sumlin, but I have not reviewed specifically what the state has pulled out, so I need to do that.
Okay. Is that kind of true for everybody?
Yes.
Okay.
Could I ask one question?
Yes.
In this folder that appears to be a bunch of audio files, the first folder under Sumlin, am I correct in my belief that that is all the calls from the wiretap that you all seek to introduce at this time?
No, so these are the calls from the wiretap, primarily looking at the ones that we identified for the co-conspirator statement. So some of these will probably be reduced by the co-conspirator statements once we reduce those as well. But this is just a duplicate of that folder.
Understood. So it may shrink.
Yes, yes. And we would have identified all the Sumlin calls once we finish with the co-conspirator analysis.
When are y'all gonna finish that?
That's what we're working on, that the court asks us to have a reduced list by next week.
Okay. So do y'all maybe want to take today to work together and or separately on a whole lot more of this stuff? Okay.
Yes, I think that would be beneficial, Your Honor, and
All right.
productive.
All right. So I don't want y'all to leave and go home and do something else. I want y'all to stay here and work. Okay.
Yes.
All right. So
Stay in the courtroom, or can we stay in our office and work?
you know, I mean, whatever is easier. If it's easier to sit here together and say, you know, things like you've been saying. So, hey, I'm looking at this. Is this what it is? And is this going to be the entirety of it?
Not
Or
just
are
the
you
end of the
going
day
to
at
narrow it
9:45.
down?
Oh my
What are the
God.
timestamps? I mean, it might be a good idea to just sort of, and the defendants can go back, but the attorneys sort of, you know, review evidence together. Yes.
Maybe my colleagues are going to throw some tomatoes at me, but if the defense attorneys could maybe take a certain amount of time in our little side office and go through, and then maybe either all of us or some representatives could meet with the state at some point today and discuss where we're at. But as I understand it, the information that we would be reviewing on our own would be the contents of this Dropbox minus the wiretap stuff.
Yes, that's fair. Yes.
And we're not going to watch as a group that all the Axon folders. We're going to wait for you all to give us direction on the timestamps on the body cam stuff.
Yes.
All right. And I don't mean just this folder. I mean folders, you know, whatever this is, 52 through 103.
I meant the Dropbox.
Yes.
The entire Dropbox.
Okay. Yeah. And to the extent, I mean, we didn't have the Dropbox for 31 through 60 up yesterday when we were walking through those witnesses. We were doing something more general than that. But when y'all get through all of this through 103, if you want to jump back and just make sure we covered everything on those others, you know, do that as well. But then I think maybe the next time we get together, it'll be more productive. Okay. So I'm going to adjourn us from our trial for the day, and the defendants can be returned unless y'all feel like you need them. But it doesn't, this seems more like attorney work to me. Y'all tell me if I'm wrong.
After consulting with my colleagues, I think we are okay. We are fine with if just the attorneys remain and the clients are allowed to return.
Okay.
Back.
All right, so let's do that. And then today's Friday, so we will reconvene, let's say, Monday at 8:45. All right, and y'all spend the day being productive and with your unexpected extra time. All right, you're welcome. And so will we be able to?
Okay, well, guess we're done for the day. I will see you guys later. I'm gonna get some work done, but that was very interesting. Uh, I'll check back in around lunchtime, guys. I guess we can all have a productive day today. See you guys later. Oh, wait. We will come back for Fonnie's hearing. Let's see. Let's see if it's on. Yeah, I don't know if it's on. Okay, so yeah, I saw that too. Friday the 13th. Wow. Okay, so let's see. The Senate meeting. Well, nothing happened today. They're not ready. The jury's not here, so no testimony could be presented, and that's it. We'll play some old stuff. Let's see.
Is he out?
Let me know when you get down to
Is Mr. Copeland out?
No, he's upstairs.
Okay, okay, good. All right.
Yeah, come on down. Don't come in the court. Come and get you back.
This is old stuff, guys.
Thank you.
Go ahead.
The way I understand my constitutional obligations pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, he did not
Good
come
day,
into the
guys.
courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question.
And
How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
and you haven't answered my question yet.
I'm not
How
going
did
to
you
answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information. Then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying
and he'll sit for 2 years, and then supposedly
That's
this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who the. Tell me who this information was coming from.
I don't want to be held in contempt.
Well,
I'm not
then
answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what. I'm going to give you 5 minutes. If you don't
It's
tell me
not
who
that.
if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
I have an idea how you got it, but
anything.
Okay, but
1.6.
I know what the rule says, but here's the thing.
Well, let me just.
In order, you need to please tell me who you got it from. I'm not asking you sum and substance.
He even
or
tried to
anything
get
as of
nice.
yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers
Like it's
parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
Ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not sum and substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think.
Morning. We have, first we need to approve our minutes from the last minute, and then we have subpoenaed Fonnie Willis to testify. According to press reports, she is defying her subpoena and not appearing, but we will welcome her if she appears at some point during the meeting. We also will have a presentation by Mr. Stuart Morelli of Legislative Counsel's office. If you look in your folder, you will note that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative investigation, administering oaths to witnesses, and issuing subpoenas. So we are guided by their work and their legal advice. So I wanted Mr. Morelli to kind of educate the committee and the public on this process of an investigative committee, as well as our subpoena powers. Following that, Mr. David Cook, our former Secretary of the Senate, who's been very involved guiding this committee through the process, will give us some insights from his expertise in legislative procedures and the authority for legislative investigations, the rules that govern legislative processes. And these gentlemen will both be available for questions if we may have them as they try to inform us of our legal standing. So I'll wait just a minute, let everybody take a look at the minutes. We actually have two different meetings that we needed to approve the minutes. We lost our quorum last time. I'd want to start with the May 23rd meeting. If anybody just has any questions about that, just take a look and it'll remind you what we've been doing. I was surprised to see in the press that this is our 6th meeting of the committee. It seems like they're moving pretty quickly as we've been in action since back during the legislative session. I expect we will have 2 or 3 more meetings this fall, and we are continuing to get information from members of the public that have concerns and questions and proposed testimony. So we'll have plenty to do as we complete our mission of investigating some of the alleged misconduct and also ways to improve our statutory authority and laws that govern some of the areas that we've heard testimony on. Everything from special grand juries to special prosecutors to funding aspects of district attorneys' offices and accountability for the expenditure of public funds. Those type of things we'll all look at before we come up with final recommendations of the committee. Having reviewed these minutes, is there a motion to approve the minutes from the May 23rd meeting?
Mr. Chairman,
Yes.
I wanted to just make a comment.
Hang on one second.
I was not
Mr. Leader.
Okay. I was not present physically at the meetings, but I did participate online. There was not a Zoom function, but I listened to it. And so since questions weren't asked, I feel like I wanted to make that be put on the record. But with that being said, I would make a motion to approve the minutes as presented.
Was there one particular thing about the May 23rd meetings you had a question with?
No, sir. No.
Questions not being asked?
No.
Okay.
This time, but you did a good job as always.
Well, I appreciate you participating by online with us. I recognize we have very busy schedules and lots of travel in the off season. So we're trying to announce these in far in advance as we can. A couple of them did kind of sneak up. So Mr. Pro Tem, you are recognized.
Yeah, Mr. Chairman, similarly, I think I got circumstances, but I was trying to get here, maybe got caught in traffic, but I too was listening in as well.
Well, we wrote
right
you
before.
down as arrived at 2:57. You were tardy.
I was
So
tardy.
We
I know
know
I
you
got
were
here,
participating.
but I was doing what I could to get here and listening on the way.
That particular meeting on May 23rd, we started at, we were planning to start at 2 in the afternoon, I think, because we knew we had some travel problems. So thank you for your efforts.
Yes, sir.
All right. Any other discussion? Is there a motion? We have a motion to approve and a second by Senator Dolezal. Any further discussion on the minutes of the May 23rd meeting? All right. All in favor of approving the meetings, vote aye.
Aye.
Any opposed? All right. Same thing now on the August 9th meeting, which was our last meeting. If anybody has questions about these proposed minutes.
Motion to approve.
All right. So again, we have a motion to approve. Is there a second?
Second.
Second by Senator Dolezal. Any discussion on these? All right. All in favor, say aye. Any opposed? All right. They are unanimously approved. We are also joined today by Mr. Josh Belafonte, who is legal counsel, has been retained by the committee to represent our interests in certain litigation that it's already really been filed, but it's more to come, I think, in the enforcement of subpoenas before this committee. I will expect that at the conclusion of the public portions of this meeting and the public testimony, we may go into executive session to have him, under our attorney-client privilege, advise us as to the current status of any pending litigation. All right, at this time, then I want to have Mr. Stuart Morelli introduce himself and just give us an update on the sort of the legislative process here, the investigative powers of our branch of government, and the ability to have witnesses to testify under oath, and our issuance of subpoenas. As a member of the Legislative Counsel's office, you're assigned to this committee, and we appreciate your efforts in helping us behind the scenes be prepared and follow the appropriate procedures up until this date. And you shared with me this memo that was really, it's 13 or 14 pages long that was prepared some years ago by your office. If you would just kind of give us a general overview of the research and work that you've done and the big scope of things, the legislative investigative powers.
Yes, sir. So, as the chairman said, I believe each of you have a copy of the 2016. I've always called it a manual, whether you call it a manual or a memo. It is the research our office conducted some 8 years ago in outlining the legislative investigative powers, including the abilities to issue subpoenas and compel witnesses to attend. When you're looking through that, you'll notice that a number of citations go back to, of course, Mason's Manual on Legislative Procedures, which I may also be, referencing, in my presentation today. Mason's does a very good job of, outlining the various the powers of legislative bodies, as well as the procedures in them, and cites to, case law in states to support its positions. So as a general matter, it has been found almost universally by the various courts that have looked at the matter, including the United States Supreme Court and Supreme Courts in our sister states, that all legislative bodies have an inherent power to conduct investigations. As the Supreme Court reaffirmed, the United States Supreme Court reaffirmed in 2020, that power is inherent to the legislative process, as in it does not have to arise from a specific grant of statutory or constitutional authority.
This 2020 case
Yes.
would not have been in the
No,
2016.
sir. And I'm going to provide some, that information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in 2020. In the Mazars case, the Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each house has the power to secure needed information in order to legislate. And they cited to a 1927 opinion of theirs, McGrain v. Dougherty. The Mazars case, Mazar court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1927 case in McGann. The Mazars case then went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently. As I said, in 2020, the Supreme Court was citing back to its 1927 precedent, upholding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigations going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissenting view that I'm aware of was stated by Justice Thomas in the Mazars case. He did believe that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided, but no other justices joined in that opinion. Other state Supreme Courts have continued subsequent to the issuance of Mazars to continue to also uphold state legislative investigative powers of their legislature.
Was that an 8-1 decision then? Or?
Justice Alito dissented on different grounds. He did not join Justice Thomas's dissent, so it was 7-2.
Okay.
And just for the record, the Georgia Supreme Court has never addressed legislative investigations. It just has not been an issue that has made its way to the Georgia Supreme Court. So it does appear that there is virtually no case law directly on the ability of the General Assembly to carry out or to compel testimony and compel witnesses to appear before it and to produce documents. In addition to the near universal finding that legislative bodies have an inherent power, it has also been the near universal finding of the U.S. Supreme Court and other state Supreme Courts that the power to investigate is not only possessed by the entire legislative body, but also by its constituent chambers, and that those powers can be exercised by one chamber on their own. So bicameralism has never been found to be necessary to carry out an investigation, to compel testimony for a full chamber of a legislative body. And also, the courts have universally, when the issue has come before them, held that a legislative chamber is fully within its right to delegate its legislative investigative powers to a committee, including the power to compel testimony and subpoena documents. However, the case law is also clear that absent such an affirmative delegation, a committee does not on its own have any inherent power to conduct investigations. And the investigatory powers of a committee are limited to those that are specifically granted to it by its parent body. One area in which there is not a universal holding when it comes to legislative investigative powers would come to the ability of a legislative body or a committee of a legislative body to conduct its hearings and to compel testimony once the legislative body has adjourned sine die. There is a conflict between the state courts that have interpreted this matter. Some state courts find that it is perfectly fine for a subcommittee or for a committee to compel testimony after after the parent body has adjourned sine die. Some Supreme Courts have found that it would require a joint resolution of both chambers of a legislative body to allow that to happen, finding that once the General Assembly had adjourned sine die, there would need to be some level of bicameralism for the investigative powers to be conducted. And some state Supreme Courts have held that such investigations are completely prohibited, based upon the rationale that since the investigative powers are auxiliary to the legislative power, and since a legislature cannot legislate once it is adjourned sine die, then the auxiliary power itself would disappear. Luckily, here in Georgia, we do have a constitutional provision that addresses the ability of the General Assembly to establish interim committees. Article 3, Section 4, Paragraph 4 of the state constitution provides that each house shall determine its rules and procedures and may provide for its employees. Interim committees may be created by or pursuant to the authority of the General Assembly or of either house. So the people of the state of Georgia have empowered each chamber of the General Assembly to establish interim committees as they so choose.
Let me hold up just to make sure we all understand this then. In the state of Georgia, it is in the Constitution that each body, the House and the Senate, may establish committees that's work may continue after sine die.
Yes, sir.
Okay. And so any of these other states that have varying decisions would be based on their statutory law and their constitutions.
Yes, sir. That is correct.
No Georgia court has ever held that our legislature doesn't have the authority to meet in the off season, as many of us call it, but when we're not in legislative session.
Yes, sir. That is correct.
That's why we have all these study committees that meet every year that are investigating and trying to find solutions to problems and formulate legislation.
Yes, sir.
Okay. And as far as you're concerned, does that constitutional provision also apply to investigative authorities as set forth by Senate resolution? Make sure I remember the number here. We have this in the folders as well, 465.
I see no reason why that provision would not apply to a standing or a special committee as well. It would seem to be it would seem to be limiting the power of it would just, seem inconclusive that why an interim committee could meet, but a standing committee would not, when the Constitution has authorized a type of committee to meet in the interim.
Your legal opinion that we are authorized to meet in the interim?
Yes,
by the Georgia Constitution. How about under Senate Resolution 465? Does it specify that we are permitted to continue our meetings after sine die?
I don't believe it specifically states that, but it also, unlike the resolutions that would tend to create study committees, does not provide a end date for the committee. A typical resolution committee, a study committee, talks about how those study committees tend to stand dissolved as of typically December 1st of the year they were created, absent any type of explicit date stating when the committee dissolves. The resolution would appear to indicate that this committee has the authority to continue to operate until the 158th General Assembly is sworn in. This being the 157th General Assembly.
Okay. I apologize for my interruptions, but I didn't want to forget them. So back to your presentation.
So, and this is kind of along the lines of, in addition to the constitutional provision, while there has not been any case law that addresses the ability of the General Assembly to conduct investigations, there have been, on as far as I can tell, 4 occasions where the General Assembly or a chamber has created a committee to conduct investigations and to study the affairs of the state. And in all 4 of those situations, it does appear that those committees did carry out their powers once the General Assembly adjourned sine die. I would say the clearest example of this authority comes from 1871 with joint resolutions 7, 9, and 12 of the General Assembly. Both of those, again, were adopted by both the House and the Senate. They established various joint committees to investigate the issues arising of former Governor Rufus Bullock's administration. These resolutions specifically granted to those investigative committees the power to compel witnesses and subpoena documents. Then in 1896, the House of Representatives, and through a resolution, established a committee to investigate each department of the state government. The resolution was adopted on the day that the General Assembly adjourned sine die, so there was no way that that committee could have carried out its functions during the session. Based upon the House journals, it does appear that that committee did conduct extensive investigations in the interim in 1896. In 1897, the committee filed its report with the House, and the committee report and the minority report go on for about 86 pages. They provide a very in-depth, detailed examination of the affairs and operations of the various state departments. This committee apparently went to the offices of each state executive officer, inspected their books, investigated their practices. There is a in-depth discussion of the ability of the affairs of the Department of Agriculture at the time. It appears that the committee questioned the best practices the Department of Agriculture was carrying, not only in bookkeeping, but in contracting with various contractors. I believe it was to provide tags for seed oil. Not being an agricultural guy, I don't completely understand that. They also, there are references in the committee report to how they visited each of the state's hospitals at the time, commenting on even when they went to the school for the blind, that the dormitory for one set of students, the boiler room was lacking adequate insulation around the boilers. So it was a very in-depth review, digging into the details and operations of the various departments of the state executive branch. And again, making comments on their bookkeeping, making statements on how much funds they had. The committee made a number of recommendations, both for potential legislation to address matters that they saw, as well as to recommendations on future appropriations, whether to increase or decrease the set levels that had been given to the various state agencies. I will note that the 1896 resolution by the House does not state that it grants the committee the power to compel witnesses, but as I said, they undertook an extensive investigation. The report makes no indication of whether or not the executive branch objected, so I cannot speak to whether or not they were forced in some manner to get the executive to comply. But the report is silent as to that matter. And then finally, at least in the past 100 years, we're getting up to, in the 1964 special session, the Senate adopted Senate Resolution 30, which established an interim committee to make a comprehensive inquiry into the Stone Mountain Memorial Association. I just discovered this resolution last night and was unable to get my hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial Association also was silent as to whether or not it delegated the power to compel witnesses. I was able to see that a number of bills were proposed and adopted in the 1965 General Assembly, revising various provisions of the law governing the Stone Mountain Association. So I would make the assumption that the committee did make some recommendations that led to that legislation. Enforcement of legislative subpoenas has also been a matter that the courts have been forced to address throughout the history of the United States. Going back to 1821, the United States Supreme Court in the Anderson v. Dunn case did find that each House of Congress did have the inherent power of contempt. In that case was an actually case where a gentleman was detained by the Sergeant of Arms of the House, and he had sued under habeas corpus to get his release. And the Supreme Court did uphold the finding, the Federal House of Representatives finding of contempt, the power to find him in contempt for refusing to come testify before them. In addition to the inherent power of contempt that most courts have found that legislative bodies have, judicial enforcement of subpoenas has kind of been the more modern practice if a state has not adopted a specific statutory procedure for enforcing its subpoenas. There are some states, like New Jersey, for example, has a very detailed provision for the enforcement of legislative subpoenas that ultimately can result in a person being held in criminal contempt if they fail to abide by a subpoena. In Georgia, we do have a couple of statutes on the books that do provide some degree of guidance for judicial enforcement of legislative subpoenas. One that I will not spend a lot of time addressing, nor does the manual, are the provisions in Title 28 regarding the House and Senate ethics committees. Those are really much more designed to carry out ethics investigations into members of the General Assembly themselves. Of course, we can get into that if anyone wants, but they are not. Those provisions don't seem particularly pertinent to the present committee. In addition to those provisions, there are the provisions of OCGA 48-15-17 and 45-15-17 and 45-15-19. OCGA 45-15-17 provides the authority to the Attorney General to conduct investigations into the affairs of the state, and does now provide procedures by which the Attorney General can compel people to appear before his or her investigations, subpoenaing those witnesses and subpoenaing documents as part of those investigations. In the event that the Attorney General is forced to enforce, if somebody refuses to comply with one of the Attorney General's subpoenas, the code provides that the Attorney General has the ability to go to the Superior Court of the county where the person to whom the subpoena was directed resides to seek judicial enforcement. OCGA 48-15-19 grants both the governor and the General Assembly the exact same authorities that are granted to the Attorney General in 48-15-19. While these statutory provisions do exist both in 48-15, both in Title 45 and in Title 18, they in no way override the General Assembly's inherent authority to conduct investigations, or its inherent authority to carry out contempt procedures, or its inherent authority to attempt to enforce its subpoenas. Article 3, Section 6, Paragraph 3 of the state constitution provides that the General Assembly shall not abridge its powers under this constitution. No law enacted by the General Assembly shall be construed to limit its powers. Therefore, the provisions of Title 45 and Title 28 are not limitations upon the General Assembly's power. They are additions to its inherent power, and have probably been enacted to provide some guidance to the judiciary if the General Assembly is ever in need of its assistance in enforcing its subpoenas. Absent some sort of statutory provisions for the courts to refer back to, it would appear, and this has been the case in some of the older case law from other states, is that the courts are then forced to resolve disputes into legislative subpoenas using their equitable powers. So it just, at that point, it gets much more complicated for the courts to determine those matters absent some sort of statutory guidance provided. One area that is not addressed in the manual, but I felt needed some updating, especially in light of the Mazars case, are questions regarding separation of powers. And the Mazars case does lay out that courts, when considering legislative subpoenas, in certain cases in Mazars' case, the president, need to show some heightened concerns to recognize the separation of powers. However, one thing that the Mazars case is very clear about is that it is limited to issues regarding congressional subpoenas to the President of the United States. As the Mazars court says, the president is the only person who alone composes a branch of government. It goes on to state, the interest of the man is often connected with his constitutional rights of his place. A balanced approach is necessary, one that takes a considerable impression from the practices of government. Courts must perform a careful analysis to take adequate account of the separation of powers principles at stake, including both the significant legislative interests of Congress and the, quote, unique position, unquote, of the president. So it would appear that the Mazars Supreme Court in the Mazars case, when they're setting these heightened standards of separation of powers, is designing that to specifically address the unique arrangement in the federal constitution where the president is the executive branch under, I believe, what is generally called the unitary executive theory. Two state Supreme Courts, as far as I'm aware, well, two state appellate courts have addressed the Mazars case and how it applies to state separation of powers issue. The first court case was the Montana Supreme Court, and I can give you all the citation for that case if you give me a second. Sorry, there we go. McLaughlin v. Montana State Legislature. In that case, the Montana legislature had subpoenaed the court administrator to request all emails that the court administrator had with the various judges of the Montana judicial branch to investigate whether apparently the Montana legislature had been considering some legislation regarding, I think, judicial compensation or some such. The judges circulated a poll amongst themselves, and the legislature was interested in the results of that poll. Ultimately, the Attorney General of Montana, challenged legislative subpoenas, and the Montana Supreme Court did find that separation of powers in that case did require, and citing favorably to the Mazars case, that the legislature had exceeded its authority. Ultimately, the Montana Supreme Court found that Montana, similar to Georgia, has a procedure for judicial punishment, and that the alleged purpose of the subpoena was to investigate whether or not the judges had complied with the Open Records Act, and the Montana Supreme Court determined that that was not a function of the legislature, since there was an established procedure for the punishment of judges. The Montana Supreme Court found that the resolution setting out, or the subpoena issued by, it was, I believe, the Standing Judicial Committee of the state Senate there, did not properly detail a legislative purpose beyond seeking to see if the judges had complied with their Open Records Act. The other state appellate court that has addressed the Mazars case would be the Commonwealth Court of Pennsylvania, which I believe is their intermediate appeals court. The Pennsylvania Commonwealth Court in Costa v. Ward found that Mazars was not applicable to an issue arising when the Assistant Secretary of State of Pennsylvania attempted to quash subpoenas issued by their state Senate. The Costa Court, the Pennsylvania court, did find that the Mazars case was limited in scope to the specific unique role that the president has in the federal system. However, we also have a Georgia case, which is not directly on point, but it does address the issue of separation of powers when it comes to governmental investigations. In 1975, the Supreme Court issued an opinion in Dean v. Bolton. In the Dean case, the lieutenant governor had requested the governor to request the attorney general to conduct an investigation into the travel and expense accounts of a state senator. That investigation was conducted under the previous version of OCGA 48-15-17 that it occurring before the OCGA was codified in 1983. I don't have the specific site. The language, though, the statutory language had not significantly changed in that, in that period of time. The senator challenged the investigation on the grounds of the state's separation of powers clause, constitutional separation of powers. The Georgia Supreme Court went on to provide, let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. So,
But hold on right there. That sounds directly on point, if you ask me.
It was not directly arising out of a legislative subpoena. It is directly on point to the statutory provisions that the General Assembly has and were cited to in the resolution establishing this committee.
And those are the same statutory provisions recited in our resolution forming this committee?
Yes, sir.
Or their predecessors?
Yes, sir.
Would you give me the citation to that case?
Yes, sir. I'm sorry. I've been a bad attorney and not giving you the cites.
You got a whole bunch of attorneys on here. You got a couple of non-attorneys that are as smart as you.
And I can provide copies of any and all of these cases to any members who wish them. The citation for Dean versus Bolton is 235 Georgia 544. And again, it was a 1975 case.
Yeah, all right, so that's Dean versus Bolton. Yes. 235 Georgia 544.
Yes, sir.
All right, so would you read that holding one more time? Because it sounded like it said that the executive branch, Attorney General in that case, did have the authority to subpoena records concerning improper conduct in office of a state senator, dealing with the travel and expense reimbursements.
Yes, sir.
And that same code section that gives the Attorney General that authority is what we're traveling under here, that gives the same powers that the Attorney General has to the state legislature.
Yes, sir.
Am I right?
Yes, sir.
Would you read the holding that you just read us again?
Yes, sir.
Okay, thank you.
Let it be sufficient here to say that this constitutional provision does not prohibit a person in the executive branch of government or a person in the legislative branch of government from investigating the official conduct of any person performing duties in any branch of government. The General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations.
Okay, so what we're doing is constitutional.
Under the Dean holding, it would appear so, yes,
And
sir.
that's a holding that's interpreted in the Georgia Constitution.
Yes, sir.
And our separation of powers allows the legislative branch to investigate other branches of government, other individuals and their conduct in office.
That is definitely what can be taken from the Dean opinion. Yes, sir.
Pretty much
As well as
clear
the-
wording of it.
Yes, sir.
Okay. And that was the factual scenario in that case, was looking into the conduct in office of a state senator.
Yes, sir.
All right. That's the only Georgia Supreme Court case dealing with this separation of powers, whether the legislative branch can investigate.
Yes, sir.
Okay.
As far as it was the only one that I found.
Still good law now.
Yes, sir.
And there's no constitutional provision that has been changed that would change the circumstances from 1975 until today.
No, sir. I believe the separation of powers provision of the 1945 Constitution was carried over verbatim into the 1976 and 1983 Constitutions. The only potential relevant change is, of course, the addition I talked about interim committees, which was apparently an addition in the 1983 Constitution.
And that 1983 Constitution is the current version of the Georgia Constitution.
Yes, sir.
Okay. All right. So before you veer.
Well, I have now reached the end of my prepared
Okay.
notes.
We're going to get some more out of you then. Back to the United States Supreme Court. Of course, that applies nationwide, right? Those those holdings?
Those holdings apply to the federal government because it is interpreting the provisions of the federal constitution as it applies to the Congress's power. Those opinions are not binding precedent on the states, but have largely been taken as authoritative precedent. But, as I, said when my discussion about the Pennsylvania court did not accept Mazars as binding precedent, whereas even the Montana Supreme Court, when the state Senate asked for a motion on rehearing, the Montana Supreme Court in their petition to deny rehearing did state that they were citing Mazars only as authoritative precedent, but in no way claiming that it was binding precedent upon the state of Montana.
So when we talk about the idea of legislative oversight, legislative investigations on the federal level, there's a line of Supreme Court cases that say this is an implicit or inherent power of the legislative branch, that you have the power in order to do your job of passing laws in the public interest, creating public policy. You occasionally have to investigate. Similar to when our committees meet during session, we routinely have hearings and have presentations by the author of a bill and any other interested citizens giving pros and cons of the bill, right? And that's necessary for the legislature to do this investigation, to do their legislative duties.
Yeah, yes, sir. The general view is that the investigative power has to be inherent to the legislative process because, again, as the Supreme Court recited in the Mazars case, without information, a legislative body cannot properly legislate, as I believe the U.S. Supreme Court said they'd be legislating in the dark.
Very similar to probably the seminal United States Supreme case creating judicial review, Marbury versus Madison. All the lawyers on this panel, they graduated law school, so they know that one. The United States Constitution never says the United States Supreme Court has the power to strike down a law as being unconstitutional. But
Correct.
They stated that power because it was implicit, inherent. Otherwise, you're a ineffective branch of government as the judicial branch if you don't have that inherent power to set the rules, what is and is not constitutional, right?
Correct. Yes, sir.
Same type of principle here on legislative investigations, that is an inherent legislative authority, whether the U.S. Constitution says it or not.
Yes, sir.
But the Supreme Court, it says they got it.
Yes, sir.
Even though it's not articulated in the Constitution.
Yes, sir.
Any reason that should be different at the state level?
No, sir. In fact, some of these, what I've seen in some of these state Supreme Court rulings is they find that inherent authority can also be justified under a separation of powers because absent, the ability of the legislature to investigate on its own, would be highly dependent on information provided to it by the executive.
So even if Georgia's Constitution did not give an investigative power to the legislature, it would be implicit if in keeping with the United States Supreme Court's interpretation of the separation of powers.
Yes, sir. Yes, sir.
And the provision you read out of the Georgia Constitution, does it essentially give us that constitutional authority?
The state constitution does not give an explicit power to it and to conduct investigations. It does specifically authorize the provision I cited specifically gives the General Assembly and its chambers to establish interim committees to conduct, activity once they've adjourned sine die. Since the General Assembly cannot legislate post sine die, really the only activity those committees could take would be studying or investigating.
And that's what we're doing, studying and investigating here. The Dean versus Bolton case was a Georgia Supreme Court that says the legislature does have investigative powers.
Yes, sir.
Okay. So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations that the legislature has an inherent ability, power, authority to investigate.
Not in so many words, but I would say that your statement is correct.
Okay. And this committee, in our resolution that formed us, and I'm going back to Senate Resolution 465, says at line 81, section 4 here, the chairperson shall call all meetings of the committee. Committee may conduct such meetings at such places and at such times as it may deem necessary or convenient to enable it to exercise fully and effectively its powers, perform its duties, and accomplish the objectives and purposes of this resolution. That in no way limits the meetings to just during the legislative session, does it?
I do not read any specific limitation.
It's whenever the chairperson calls the meetings and at any places and times as we deem necessary to do our job, right?
Yes, sir.
Okay.
Up through I would say up through when the next General Assembly is sworn in on the second Monday in January 2025.
So to that point, we're no longer in office. The biennial is over.
Yes, sir.
Might be in office if we're lucky enough to be reelected and have chosen to run, but otherwise it'll be a new General Assembly then.
Yes, sir.
Okay. Is it your legal opinion that we are authorized to conduct investigations and hold meetings and take binding actions up until, I guess that's the second Monday in January of 2025?
That would be when ultimately this committee disappears along with the 157th General Assembly itself.
Okay. And let me shift your attention a little bit to the resolution itself then. Because I'm looking at this as sort of three various grants of authority to this committee. Number one is this constitutional authority, whether specified precisely in the Constitution or just the implicit inherent powers that have been validated in the Dean and Bolton case, at least. Additional statutory powers under the statutes you've referenced. Those would be not limiting, but in addition to this inherent or implicit power, right?
Yes, sir.
And then the powers given under this Senate resolution that was passed and became law authorizing this committee.
Yes, sir.
Okay. In that, can I direct your attention to that resolution? It's in each person's folder as well. Okay. On page 3, starting at lines 45, I'll just read, whereas such inherent powers include the authority to create special committees for the purpose of conducting investigations and to endow such committees with all the inherent powers of investigation possessed by the Georgia Senate, including the power to compel the appearance and testimony of witnesses and the production of records and the power to place witnesses under oath or affirmation. Does that language specifically give us the power to subpoena witnesses to testify before this committee?
Yes, sir. It would appear to me that it does.
And to produce records for our investigation in the course of our duties?
Yes, sir. That paragraph does appear to be an explicit delegation of the Senate's inherent powers to this committee.
Is this in any way inconsistent with any statutory authority in Georgia or constitutional provisions in Georgia?
It is not contrary to any constitutional provision, and because it is the inherent power of the body arising from the Constitution, I don't believe a statutory provision could conflict with it.
Okay. The resolution goes on in lines 50 to 54 to say, in addition to such inherent powers, Code sections 45:15:17 and 45:15:19 empower the General Assembly to make investigations into the affairs of the state and further authorize compelling the appearance and testimony of witnesses and the production of records, and grants the power to place witnesses under oath or affirmation and to enforce subpoenas issued pursuant hereto. Is this just an additional power to subpoena?
Yes, sir.
Okay. And that's what's contained in those two statutes?
Yes, sir.
Okay. Tell us about those two statutes.
Yes, sir. Again, 45, 15, 17 is the statute that grants investigative powers to the Attorney General that I talked about earlier, including the ability to subpoena witnesses and to compel the production of documents. It also does provide the procedures for enforcing those subpoenas, whereby if a person refuses to comply with the subpoena issued by the Attorney General is empowered to seek judicial enforcement of those subpoenas by going to the superior court of the county of the residency of the subject of the person to whom the subpoena was directed.
And does that statute give the legislative branch the same powers and authorities as the Attorney General?
OCGA 45, 15, 19 gives the General Assembly the same powers that the Attorney General has in 45, 15, 17.
So those powers of the Attorney General to subpoena and compel testimony or documents is granted to the General Assembly in 45. You got that?
15, 19.
15, 19.
Yes.
Okay. And that's recited in our resolution that formed this committee that we possess those powers.
Yes, sir.
In addition to the power granted through the resolution itself, and in addition to our inherent constitutional powers.
Yes, sir.
So, okay. Do you have any question that this committee has the power to subpoena testimony or subpoena documents in furtherance of the duties set forth to this committee in the resolution 465?
No, sir.
Okay. Any other senators have questions? I want to recognize the minority party as our rules provide to ask any questions. And Senator Jones, I'll look to you since you've done that. Since this is more of a presentation than sworn testimony, since he's counsel for our committee, I'm going to defer to you. But then if other committee members have specific questions, unless there are objections, we'll do that. Right? You have the floor.
I just
Make
have
sure
one.
you lit up. All right.
And that was the 4 instances that you gave about them, I guess the committee doing an investigation after sign or die. You got to go back into that a little bit more. And it was the last time that happened was in 1964. Is that correct?
Yes, sir. The last time that I'm aware of a committee being created, a committee being created specifically to investigate a specific part of the state government was the 1964 resolution that the Senate did regarding the Stone Mountain Association.
And obviously no one has never come up. So this would be a case of first impression, I guess.
Yes, sir.
If it goes to court. Have anyone given any legal opinion about why they may believe that they are not subject to subpoena? Like, what's the counter argument? I'm just curious.
My understand, they're people who have court, like in the Montana case, the court administrator did argue that the subpoena went beyond a legislative purpose. There are limitations that a legislative subpoena must be in furtherance of a legislative purpose, and so there are many instances where people have challenged a subpoena issued by a legislative body, alleging that there is no legislative purpose behind this investigation.
And do you think that would apply in this case? Or of course, we don't really know, do we?
The resolution, under my understanding of the resolution, is that it is designed for this committee to investigate potential legislation to be introduced regarding potential matters of appropriations regarding district attorneys, the contracting procedures, especially in regards, I think it specifically references hiring special prosecutors. So my understanding of the resolution is it does outline a legislative purpose for the committee.
Yeah, I think you're right. Thank you. That's all.
And doesn't it specifically direct us to investigate the conduct of District Attorney Willis's alleged conduct?
Yes, sir.
So it wouldn't be out of line to invite or to compel her to appear.
This
Then, would
is the Senate meeting. Fonnie was under subpoena.
Is
We
in
were
furtherance
supposed to see
legislative.
if she showed up. That's what we are watching.
It's fair to give her a chance to defend herself and give her side of the story. Agreed or not?
I have no position on that, sir.
That's the lawyer answer. That's good. And that's what we pay y'all the big bucks for, is just give us impartial advice. Thank you. Other committee members with questions? Senator Tillery, I'll recognize you for the question.
Thank you, Mr. Chairman. Thank you, Mr. Morelli. I have one question. I heard you read the Dean opinion that talked about let it be sufficient to say the constitutional provision does not prohibit a person from the executive branch from investigating, or from the legislative branch from investigating. Then I want to go to that next paragraph though, because you've studied this more than we ever will. The sentence that said the General Assembly may by statute place limitations on such investigations or enact procedures for such investigations, but there is no constitutional prohibition against such investigations. In your research, I understand where you've tied this up, but I want to look at the little hole here and say, have you in your research found any statutes or procedures that the General Assembly, since this decision, have enacted that would limit that power that you discussed that Dean appears to give?
Yes, sir. Actually, following the issuance of Dean, or almost concurrent potentially, the predecessor to OCGA 45-15-17 was amended in 1975. And one of the provisions added at that time, and I'm going to pull that was a subsection D to OCGA 48-15-17, which specifically provides that nothing within that code section shall authorize the Attorney General to investigate members of the General Assembly during session.
During session.
Yes, sir.
So if we carried that same provision over to 48-15-19, then
that statutory provision, of course, could not, but the Constitution does grant each chamber of the General Assembly the ability to, govern and investigate. There is an inherent and constitutional power of each chamber to govern the conduct of its members.
Gotcha. So that whole would not be able to eviscerate the power that it appears that we have through the Constitution and then through the progeny of Dean.
Correct. And further backed up by the provisions of the ethics provisions of Title 28, which were subsequently added much more, I think, in the early 2020s, the detailed ethics provisions that give a second independent statutory procedure for the ethics committees to issue subpoenas.
All right, other questions? I would, Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA 45-15-17 and 19. When were they adopted into law, and by which governor was it signed?
I don't know which governor. They were initially enacted into law in, I do have that before me if you will give me a second. It was in the 1950s. I do know that much. I want to say 57. I don't know who the governor was.
Any stories behind the reason for the laws at the time?
My research did not delve that far. I've saw the statutes are on the books, and in preparing for today's meeting, I went and pulled when they were initially enacted, but I did not do any further research on what may have created them.
Thank you.
Caused them.
All right, I would advise all committee members that Mr. Morelli is available to all of us if you want him to follow up with any further cases or explanation or updates. You're all free to contact him directly. He is assigned to this committee as a resource to each committee member. The memorandum, they call it the manual on investigations and subpoenas, was done back in 2016. We each have a copy of that in our folders, and it sounds like he's done some updated research. I just have one more question. We need to move on. That Supreme Court case, is it Mazars that you're saying?
Mazars.
Mazars. Is that one where the president was objecting to subpoenas from some congressional committee?
Yes, sir. A variety, I believe multiple committees of, I think it was the House. That was the case where they attempted to get his bank records. Mazars USA was one of the accounting firms, I believe, that personally worked for President Trump and his businesses. One of multiple, I believe, House committees attempted to obtain documents from them. Trump
So they
President
objected to
Trump,
the.
President Trump objected to his bankers releasing the documents. So
did the Supreme Court force them to produce the documents in
the Supreme Court overturned it. Both that I believe there were cases both before the U.S. District Court for the District of Columbia and some in the Southern District of New York. Both of those trial court levels did go up to the relevant courts of appeal. Both the D.C. Circuit and I believe the Second Circuit upheld the subpoenas. The cases were merged before the U.S. Supreme Court, and the Supreme Court found that both the various courts of appeals and district courts did not sufficiently consider separation of powers issues relating to the president, remanded the matters back. I believe ultimately the various trial courts and courts of appeals allowed the committees to get some documents, but not as many as they had initially been seeking.
Yeah, and so the limitations on those subpoenas were due to the presidency, not other government agencies.
It was based upon the finding that a legislative subpoena on the president's personal documents so interfered with with the entirety of the federal executive branch, because under the unitary executive theory, the president is the executive branch.
So is this when they were trying to get his tax returns?
There is separate case law on that. That did go up. I believe they did get those. Those are based on statutory grounds.
From Ms. Willis's tax returns. Senator Dolezal, do you have a question?
I do have just really one quick question. Mr. Morelli, would it be accurate to say that this February 26th document it essentially serves as a basis for the authority delegated to this committee in Senate Resolution 465?
It is intended. The reason I call it a manual is because it was intended by our office to be a guide to members and committees of the General Assembly on how to carry out investigations if they wished.
Is there anything that you've seen in Senate Resolution 465 that's in conflict with either the manual or anything that you have since discovered in your legal research, whether it be in Mason's or previous court precedent?
No, sir.
Thank you.
All right. Thank you for being with us. Don't leave us, but go back to your role here behind the scenes, advising us and watching. And if you think of additional information or new cases come to light that you think will be educational to our committee, please present those to us along the way.
Yes, sir.
Okay. Former Secretary Cook, please come forward. So good to see you again. Thank you.
Now get out of your way. Stick around. Do you want me? I mean,
no,
Chairman has dismissed me, but
you're not dismissed. You're just taken off the hot seat. If you want to sit up there, you're welcome to, because you guys are both just full of knowledge. That's good for us.
I'm going to go back to my preferred spot, hiding in the corner.
All righty. We do. You'll raise your right hand. I'm going to swear you in for the committee. You swear the testimony you'll give before this committee will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right. Please state your name, your previous position, and tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there. My name is David Cook. I am the former Secretary of the Senate. I received my law degree from the University of Georgia in 1982 and have been associated with the Senate actually going back to 1977. And the Dean case that you were talking about earlier, I remember very well. It was my first year as the reading clerk for the Georgia Senate when Roscoe Dean was tried on my birthday, January 27, 1977, in front of the Senate for a contempt proceeding. So I was kind of chuckling when that case came up.
We are
But
watching.
I've been associated with the Senate in one way or another for a number of years. I was Secretary of the Senate for the last 11 years and retired at the end of last month.
Well, in your role, you have been a great guide to the Senate and the Committee on Assignments and other senators that have had procedural questions and issues, and you've been a great help to me, providing me just binders full of information, especially on how investigations have been conducted by legislative branch at all levels of government. So I wanted you as sort of a subject matter expert to tell us your thoughts today. Just give us your preliminary reviews and talk to us about the power to investigate of the legislative bodies, the Senate in particular.
Good. Well, thank you. I think the question before the committee obviously is, does the committee have the authority to investigate, to subpoena witnesses, and to compel production of that testimony or of documents? And I am of the opinion that the Senate clearly, and that this committee clearly has that authority. I'm in agreement with counsel who just testified here. I think he did a good job of laying out the law regarding the power to investigate. I want to come at it more from a parliamentary law, parliamentary procedure standpoint, but there's no way to separate those two out. They are both intermingled. So Stuart may have some comments on what I may say, or I'm going to provide some of my understanding of what I think the law says. But I'd like to start to basically give you what I think is an analysis from the viewpoint of parliamentary law and procedure as to why this committee does have the authority to do the investigation, to subpoena witnesses, and to enforce those subpoenas. I would first touch on a few principles of parliamentary law and then move on to our rules of procedure, parliamentary authority that has been adopted by the Senate, and hopefully demonstrate that this committee was one properly created, that the subject matter of the investigation is legitimate, that the committee has the power to meet during the interim, which we talked about a little bit, that the committee has the power to subpoena the testimony of government officials and to enforce those subpoenas. So before I begin on the parliamentary path, I think it's fundamental that we tip the hat to the 100 or more years of U.S. Supreme Court case law that says a legislative body has the power to investigate. I don't really know of any court that has said a legislative body does not have the power to investigate. There are some differences when you get down into other issues as, do you have the power to subpoena? Do you have the power to compel that? And I think the contempt power of the Senate, for example, provides some limitations, but there are other avenues to enforce subpoenas as well. So I think the analysis Stuart gave regarding the inherent powers of the Senate is very important. It's what most everything that we're talking about today is based on. Mason's manual, which you referred to a little bit, is recognized as the modern day parliamentary procedure manual for state legislators and legislatures, and is for the Georgia Senate. It's actually interesting. There have been 3 iterations of this manual. The very first one was by Thomas Jefferson when the country was instituted, called Jefferson's Manual. And out of that arose Cushing's Manual, which was used in the 1850s. And in the early 1900s, the state of California, Paul Mason, developed a very robust manual of legislative procedure, and it evolved into what we have today as Mason's Manual of Legislative Procedure. It's the authoritative manual on parliamentary procedure for state legislatures.
Is this the one that the National Conference of State Legislatures has adopted?
That's correct.
Yeah.
California granted NCSL, National Conference of State Legislatures, the actual rights to this in the 1980s. And since then, NCSL, they have a committee of parliamentarians that sit on this, and they update it every decade. So the most recent edition is the one that was updated in 2020.
Tell the committee and the public that's listening to you what NCSL stands for, what that organization is.
NCSL stands for the National Conference of State Legislatures, and it is a national association that is comprised of, to my knowledge, every state legislative body in the United States. And it draws on the expertise of members of the legislature and staff to help the state legislatures perform their functions as legislative bodies.
Well, it just so happens that Senator Kennedy and myself were at their national convention this summer.
Mm-hmm.
And there was a session on, I believe it was titled, Everything You Want to Know About Legislative Subpoena Power. 3 different states had presenters and all unanimously said their states had upheld the power of the legislature to do investigations and use subpoenas. It's funny that issue happened to be, addressed this year, but it was certainly reaffirming to us that all the states claim this power and exercise, and it's been upheld.
Right.
Back to Masons.
Yeah. And to my knowledge, there's been the power to investigate is derived from the grant of legislative authority that has been given to the General Assembly by the Georgia Constitution. And everything kind of derives from that legislative power. The interesting thing about Masons, the good thing about it is that when you look at our rules, Senate Rule 10-1.5 provides that when any question that's not provided in our rules, which arises and not provided in these rules, the same shall be controlled by the most current edition of Mason's Manual. So the Georgia Senate has adopted by its own rules everything that's in Mason's Manual. Obviously, there will be a few things that are a little inconsistent and where we are more specific on it. For example, there's some question about whether you can meet during the interim, but we have a Georgia constitutional provision that allows us to do that, which would override Mason's Manual there. So we've adopted Mason's, and we'll be citing that throughout. Both, I think Stuart cited it, and I'll certainly be citing it. Before we get into the substance of the rules, I think it's important to touch on how rules of procedure are applied, and Mason's does a really good job on it right at the beginning of Mason's. In Section 4, it puts it pretty succinctly. Mason says that the rules of parliamentary procedure are derived from several sources and take precedence in the order listed below. Those principal sources are, number one, any constitutional provisions. So if you're looking as to how the legislative body should act, constitutional provisions and judicial interpretations are paramount. The next authority are the rules of the Senate that we have adopted. The third authority is, what is our custom? What precedents have we had? How do we normally operate? And we have several ways that we operate that involve precedent and custom. Following that, in the level of authority, are statutory provisions. So in terms of procedure, our Senate rules can trump statutory provisions regarding procedure. Then the adopted parliamentary law, which is Mason's, and then fundamental parliamentary law, which really is pretty succinctly due process requirements that are required for any legislative body, and lawyers are familiar with it, with due process in court, notice and opportunity to be heard, those kind of things. So Mason's is an important part of the Georgia Senate's parliamentary rules. I'd like to take just a minute to talk about committees, because that's what we're talking about here. There are really 3 types of committees. One are standing committees. They're provided for by our rule, section in Rule 2-1.3. And the purpose of standing committees is to look at issues that we know are going to be continuing. You have public safety, you have judiciary, you have government operations. We know that there are going to be all kinds of issues that occur during the session every year, year after year, that required the establishment of a standing committee to look at those issues. This committee is not a standing committee. The second type of issue, or committee rather, is conference committees, and those committees are created for the specific purpose of resolving differences between the houses. And you all are familiar with those on the last several days of the legislative session, where we have conference committees meet and work out disagreements between the House and Senate. And the third type of committee are called special committees. And special committees are created for the consideration of a specific task or duty, or to look at a specific issue, or to perform a specific function. These committees can also be named ad hoc, investigating, select, or study committees. We refer to them a lot as study committees here. And special committees are created by a resolution, either by resolution, they can be created by a motion from the body. In this particular case, SR 465, the resolution that created this committee, was established by a vote of the Senate. Senate Rule 5-5.1 requires 29 votes to establish this committee and pass that resolution, and that occurred in the 2023 session. So the committee was appropriately established as a special committee of the Georgia Senate. So what are the committee powers? So the creation of a committee is authorized, as I said, by a resolution. And I think it's clear, I've kind of refer to Masons here a little bit and quote them. The Masons provides that the legislature may proceed to make investigations with its authority by authorizing committee of one or both houses. So there's been some question of whether the Senate can act without the House, but Masons clearly says that either house can establish a committee for purposes of investigations. Masons also says that the right to investigate any lawful matter is a right separate and distinct in each house and may be exercised through a committee. That's Masons 795-11. So the creation of the committee, I think, was done in accordance with statute, in accordance with rules, but it was also done in accordance with our precedents. And Stuart touched on one of those going back to 1871. I think I'm not familiar with that one, but I am quite familiar with the 1964 Senate resolution that created the Senate Committee to investigate the Stone Mountain Memorial Association's Senate Resolution 30. It's actually created during a special session of the Georgia Senate General Assembly in that year, and issued a report back, I believe, in the next year. So the committee was, I think, properly established under our rules and under precedents. I think it's also important to note that committees have to be viewed as agencies of the creating body, that this committee is an agent of the Senate. And any committee can exercise only those powers that are delegated to it by the Senate. The corollary of that is that any powers that the Senate does delegate to the committee may be exercised as fully by the committee as it could by the Senate. There's U.S. Supreme Court case law on that, and certainly Masons provides the same thing, Masons 795-5. So the powers granted this committee are broad, and you touched on them earlier, and I think it's important to refer to the resolution. The resolution specifically gives this committee the power to investigate, and specifically in the resolution to investigate the office of the Fulton County District Attorney and the conduct of the Fulton County District Attorney. Masons Chapter 74 is several pages long, goes at on at length about the legitimate powers to investigate of a legislative body. And it's clear from our rules and precedent and case law that the subject area of this resolution is within the scope of the Senate's authority to do that investigation. For example, Masons provides that, quote, an investigation into the management of the various institutions of the state and the branches of the state government is at all times a legitimate function for the state legislature. The U.S. Supreme Court case that Stewart referred to, McGrain versus Dougherty, holds that an investigation into alleged malfeasance is, quote, plainly the subject on which legislation could be had and would be materially aided by the information which the investigation was calculated to elicit, end quote. The U.S. Supreme Court in Watkins versus U.S. said that Congress's power to investigate is at its peak when the subject is the alleged waste, fraud, abuse, or maladministration within a government department. That's Watkins versus the U.S. 1957 case. So the subject matter, I think, of this investigation and the authority of the committee to do it, I think is appropriate. Second, the Senate specifically delegated to this committee the power to issue and to enforce subpoenas. The resolution states, quote, for the purpose of conducting an investigation as provided herein, the committee shall have the power to administer oaths, to call any party to testify under oath at such investigations, to require the attendance of witnesses, production of documents, books, records, and papers, and to take the deposition of witnesses. The resolution goes on further and says, for such purposes, the committee is authorized to issue subpoenas for any witness or to compel the production of books, papers, and records, and is further authorized to undertake such actions as may be necessary to enforce such subpoenas in case of refusal to obey. So I don't think there's any question at all that there's been a full grant of the Senate's inherent power to this committee to investigate and to do whatever it deems necessary and proper to compel the production of testimony and documents. Further, SR 465 specifically grants the committee the authority to meet at such places and times as it may be necessary or convenient to fully exercise and effectively use its powers to perform its duties and accomplish the objectives of the purposes of this resolution. It's line 82 of the resolution. I think this language, as we touched on earlier, is broad enough to include the authority to meet during the interim, which is specifically authorized by the Georgia Constitution. Finally, SR 465 specifically authorizes the committee the power to enforce its subpoenas. The resolution states that the committee is further authorized to undertake such actions as may be necessary to enforce such subpoenas in cases of refusal to obey. Lines 77 and 78 of the resolution. So I think this is an interesting area that people don't, the next area, which is how do we enforce subpoenas, is where people get sidetracked just a little bit. And there's a little bit of a nuance there. I think there are three areas or three methods by which the Senate, and by virtue of its delegation, this committee can enforce its subpoena powers. And the first is by contempt. And that is set out in the Georgia Constitution. And there are some Article 3, Section 4, Paragraph 8. I think there's some limitation in that constitutional provision when you're trying to enforce a subpoena by virtue of the contempt power that's set out. There are different ways to enforce subpoenas, but the contempt power is one. And I think the contempt power can only be used during a legislative session. And it gets into the nature of how does a legislative body use its inherent contempt power. They get the sergeant at arms and they issue an arrest warrant, and the sergeant at arms, which has been in some of the cases and some of the very first uses of the contempt power of a legislative body. They go and arrest. I think the first one was maybe the Secretary of Agriculture, and they arrested him and brought him before the bar of the Senate, tried him and held him in contempt and imprisoned him. But that power to enforce the testimony through contempt is for punishment. And that power of punishment only lasts as long as the session, as we are in session. So once we adjourn sine die, we lose the power to punish for contempt. But there are two other ways to enforce subpoena powers. The second method is through a judicial enforcement of subpoena powers. And I think there's no question, Stuart can talk more about this better than I can, but if the Georgia Senate has the inherent power to do investigations and the inherent power to get witnesses and testimony and information in order to fully inform its legislative process, and that process is stymied or objected to or thwarted in any way, I think the Senate, and by virtue of delegation of its power, this committee can walk over to the Superior Court of Fulton County, seek an injunction in equity. Stuart touched on it, try to seek a declaratory judgment action and an injunction in order to enforce what is its inherent investigatory and subpoena powers. That's called judicial enforcement. So I would say that is the second manner of enforcing a subpoena. And the third manner is by statute. And Stuart laid out what we have is in the statute 45, 15, 17, and 19. I guess the only comment I would have there's this statute, there's a statute that authorizes the ethics committee to enforce subpoenas, et cetera. But the inherent power of the Senate and its ability to delegate that power to a committee is constitutional. I don't think anybody would disagree with that. And clearly statutes cannot overturn what is a constitutional power. So I think anytime you're reading a statute where it says the General Assembly, et cetera, that has to be interpreted as supplemental to what are inherent constitutional authorities of the Senate and of this committee. So those statutes, I think, should be viewed as supplementing what the Senate's powers are, not as restrictive of it. So those are my prepared comments today. I'm happy to try to answer any questions that you might have on this, and happy to hear from counsel on anything that I might have said from a legal perspective that he might disagree with.
Mr. Secretary, you were the secretary at the time we issued these subpoenas for Fonnie Willis. In your opinion, are they in compliance with Senate Resolution 465 within the scope permitted under that resolution?
Yes.
Okay. Anybody else have any questions for Mr. Cook? All right. Thank you for being with. Wait, I do. Senator Estevez, you're recognized.
Thank you, Mr. Chairman.
Sure.
And thank you, Mr. Cook, for laying this framework out. So my question is, are you aware of this power and even the enforcement procedures that you've laid out ever coming up before, used by this Senate body before?
And from a legal standpoint, I'm not aware of any. And Stuart, I think, can get more into that than I am. I'm not aware of. I think they're in the Dean case. There were several aspects of that, including a trial for a criminal trial. And there was a contempt proceeding in the Georgia Senate on that. And I think there were subpoenas issued pursuant to that, but I'm not sure. That would have been the only case. And then Stuart mentioned one, I think that subpoenas were issued back in the 1800s, but those would be the only cases that I'm aware of.
So 150 years ago, and then in proceedings against one of our own members.
Mm-hmm.
Thank you.
All right. Thank you very much. Appreciate you being with us this morning and all your service to the Senate for many, many years. The last person on our agenda, of course, is the first person, Honorable Fonnie Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
Mr. Chairman.
Yeah. All right, thank you. Then let's please note for the record that Ms. Willis has failed to appear in compliance with the
Oh, that is
subpoena
so
and has
bold.
failed to produce documents requested by our subpoena for the production of documents. At this time, I want to let the committee know that we have hired Mr. Josh Belafonte to assist us in our legal enforcement efforts on the subpoena. And I would like for us to have an opportunity to be briefed by him. We have privileged communications with him under the attorney-client privilege. Our rules do permit, I think it's Rule 5 of our committee rules, that we can go into an executive session or a session that is closed to the public. So that requires a majority vote of the committee. If anybody is interested in having a private conversation with our counsel to let us know where the litigation stands, now would be the appropriate time to move for that. I recognize Senator Kennedy.
Thank you, Mr. Chairman, for that. And I would move that we do pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for the purposes of hearing from appointed counsel to advise us.
Is there a second? All right, we have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, at that time, then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena. Thank you. We're adjourned.
Well, guys, I think the poll was pretty accurate. We see she did not show up. I think that is very interesting considering that I think any subpoena she issued, she would be very offended to the point that someone will be put in jail if they didn't come. So, and as a public figure, what reasons do you think, why would you not come? Like, that's just like a regular lawyer. We're all lawyers. So like, if we were subpoenaed, what reason would you have for not coming? Like, I don't understand. Why would you not just show up? That's very interesting. I honestly don't know the repercussions. I'm going to look into it. But I think the point of the meeting was basically to put on the record. They had two different attorneys to put on the record that this is how the procedure goes. This is the case law that supports the Senate being able to subpoena her. And yeah, I hope someone in that DC meet and greet session asked her, why didn't you show up? You guys are so fun. They say she's guilty of whatever they say she did. Okay, back to what we were doing. Oh, dang. I gotta go back to it, guys. Sorry. Before we were interrupted. This is what we've been watching.
I got an idea how you got it. That shit on forever.
Can you not? Cause I'm on.
Oh, they can hear me?
Yeah.
I'm sorry, guys. Well, they're gonna know who I am.
For sure. How
So holy over here.
just have a
You, but I do need to know who you had, who told you. So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want the script as of yet, because if
Okay, back to what we were watching. Lachey, so basically there was a lack of preparation today and court was adjourned at 9:45 a.m. Everybody came, dressed up nice, seemingly ready to go, except for the jury. We had no jurors. So we've just been watching the Senate meeting where the District Attorney Fani Willis was subpoenaed to be in attendance and she did not appear. So we're just watching other stuff.
any representation of Mr. Williams is been brought to court suggestion that you be here until when we've at all open sessions of court and until we finish for the day. So I'm still going to hold you in contempt. You can purge that contempt by I'm going to testify. That's reviewed. An appellate court
obviously is
I think this is where we left off.
Is Mr. Adams in the hallway over there? Could you get him, please?
I'll be right back.
He's refusing to come in. Is he refusing to come in?
wait.
Tell Mr. Adams to come inside and put some stuff on the record, please.
Mr. Adams is present.
Just hang tight, sir. All right. Mr. Adams, let me address your first refusal to go forward. We have had plenty of circumstances in this trial where you have been lead counsel and you have done more than a yeoman's job of representing Mr. Williams. And I don't doubt that that won't continue. So you don't get to have your entire defense team here. You certainly get competent counsel, which the court finds that you are in this particular circumstance. And an appellate court will review my decision for abuse of discretion. So I'm going to direct that that you continue to represent Mr. Williams. You can consult with Mr. Steele. Any breaks or anything such as that, I'll allow you to do that and continue to do that. But Mr. Steele put himself in this particular position in terms of all these. I'm not asking for any other or you for any other information that might be privileged or any other conversations, but I need to know who told you, because that then drives other things the court needs to probably do. So he's the reason as to why we're here in this particular circumstance. So if you or he or want to disclose to me who told you that, I'll be more than happy to reconsider.
I know Mrs. Steele will not. I also will not. And I respect this court. I respect that the court has to do whatever it is appropriate. But I would ask the court also respect my representation as a Williams and standing for him when we believe that there's been a violation that affects his right to a free trial. And we believe that that is the position you're in. And I would respectfully decline the court's order of continue forward.
Your Honor, may I?
Sure.
Address the court. Thank you. Your Honor, there are two things at issue here. And one of them, Your Honor, is that.
Can I ask from the court how it is that the state has any position in this particular conversation between the court and myself?
Before we recess, Ms. Love said that she was going to research this ethical issue because it is an ethical one. So just much like you could add to it, I'm asking the state if they wish to add to that as well, sir. Okay?
Thank you, Your Honor. Your Honor, we believe that there are two matters at issue here. One, obviously, is Mr. Williams' right to counsel of his choice during the trial of the case. We believe that the court has the discretion to fashion any remedy, any punitive remedy for contempt that it chooses. We would ask that the court fashion a punishment for the contempt that affords Mr. Williams the right during these proceedings while court is in session to both counsel for both of his counsels. For Mr. Steele to be present in the courtroom, he can still be held in contempt. But for Mr. Williams to have representation of both Mr. Steele and Mr. Adams while court is in session, and that the court's remedy does not affect his ability to have his counsel of choice represent him during this trial. We believe that it will need that so far this issue alone has needlessly delayed the trial of the case, and we believe that it may be in someone's best interest and in others not in their best interest for that delay to continue. So we would ask that the court, notwithstanding the finding of contempt, allow both Mr. Williams, Mr. Steele, and Mr. Adams to be present while these proceedings are going on and while court is in session. Physically.
I think that would be appropriate under the circumstances. And Mr. Steele, certainly I can inquire about before the end of the day if he wishes to disclose that information that I've asked him, then he certainly purges himself of that contempt. So yes, that's fine. We'll go ahead and do that.
And the second thing that I wanted to put on the record is that there was no substantive communication with any witness in this case outside the presence of any counsel for the defendants or any defendants in this courtroom. The matter, Your Honor, if I may finish, the matter that the state requested an ex parte audience with the court regarding was a matter to which no one to my right was a party. It was a civil contempt matter, and the parties towards that civil contempt, the state, which moved the court to compel someone to do a thing, the court compelled, and the state said, Your Honor, we're asking if the court, if they don't comply, that the court hold that person in contempt. That was a civil contempt matter. Nothing substantive was discussed. Everything was recorded, and the representations made, at least by persons who were present to the state, is that when questioned or queried about it, is that that person was told or asked whether things occurred, and that that person relayed that no substantive communication took place during that meeting.
Who is that person?
That is the second matter. And first and foremost, we just ask that the court again allow both counsels for Mr. Williams to be present when court is in session so that we don't delay these proceedings further.
All right, that's fair enough.
Thank you.
Okay,
Your Honor,
Mr. Sharp?
the ability for the state to paint themselves as the victim constantly in these matters is unbelievable. We are the aggrieved party.
Sir, we can't hear you.
My client, Shannon Stillwell, and these other young men sitting here as defendants are the aggrieved parties. We were not present. I would like to reiterate.
But here's the problem. Here's the
Your Honor, can I just-
Mr. Sharp, here's the challenge. You got the information in a way that was not lawful to begin with. Sir, that doesn't alleviate the information or make it less valid or invalid. So because we record these conversations so that they can be reviewed later. We didn't have any conversations that were not recorded. And if you heard of other conversations that were made, I don't know how you would have gotten them otherwise, because somebody had to tell you.
Okay, well, all that's great.
And like I said, if and when the case gets reviewed, an appellate court will make those decisions. But at this point,
my client is the aggrieved party. He was not present. If that violated his Sixth Amendment right to be present.
Okay, and that's your argument, sir. That's your argument. That's your argument.
One other thing, Your Honor.
That's your argument.
All I'm asking for is some sunlight to come over these proceedings.
Sir, this is not an open meeting. This is not a sunlight situation.
Release the transcript and then we can see, because we do not accept Ms. Love's representation.
Okay, you don't accept the court's representation? I'm telling you.
Like the transcript.
I'm telling you at this point in time, when the case is reviewed on appeal, if I am wrong, then certainly the appellate court can tell me, and certainly there are other bodies in Georgia that certainly my conduct can be reviewed by. But at this point, I'm telling you that's the sum and substance of it.
We are trying this case right now to win this case. We are not playing for an appeal. We would like a fair shot at this case right now. We would like the transcripts. We all know that the appellate process in this case is probably going to take decades.
Okay, well, at this point, I'm, like I said, I need to have a little bit more information in order for me to kind of make some other decisions in this case. Not saying that you may or may not get that information, but at this point, there was nothing that was improper about and the ex parte conversations. The court's more concerned about is the disclosure. So, and
I understand the court's concerned, but as the counsel for Mr. Stillwell, my concern is the meeting that he was not allowed to be present for.
okay, all right. Thank you, sir. Are you going to repeat the same thing again? Oh, let's try not to, because the Harvey rule's in effect. I understand everyone's opinion at this point in time.
The only thing I want to say, and to not be repetitive, but on Friday, Your Honor, this particular witness came in, he pled the fifth, his lawyer was present. His lawyer stated to Your Honor that he had spoken to his witness, his client, and he stated that the witness indicated that on Monday, he will also be saying that he will plead the 5th. And then, Your Honor, there was a 2-3 hour span this morning, and then he comes on and he says, I'm going to testify. That's why I believe on behalf of Mr. Huey that the transcript is important.
Okay, thank you, sir. All right, let's get Mr. Steele out, please. You can tell him to put his tie back on. And then we'll go ahead and get started at that point in time, okay? Eloquently saying that he was not going to go forward without having you present with him. So, and him not wanting to divulge who the information came from either. So, with that, sir, we're going to go ahead and continue. All right.
Ask a question.
Yes, sir.
Did the court order the transcript that we can see it and have a hearing and call witnesses?
No, I'm not gonna order the transcript as of yet, because if the case should be reviewed, the appellate court will have that particular ability to do that. I don't believe at this point in time, it is the court's understanding of the ex parte conversation that the disclosure is the more troublesome remedy. If I did something wrong, then certainly that can be reviewed. But I'm not at this point in time going to release any of the transcript in terms of what may be disclosed or that was said in Chambers ex parte at this point.
Well, I was told based upon information belief that it would affect this witness's testimony from the jury, because I was told based upon information belief that depending upon how the day goes, he may go home or not, depending upon his testimony. I'd like to know what that's about.
I don't know, Mr. Steele. I don't know. I mean, that's why I would like to know who it is that told you or disclosed this information from Chambers, because I don't know if this person even had, if that conversation was even had within my presence or hearing. I don't.
So I would like to have a hearing with the court as a witness, with the DAs as a witness, with the deputies as a witness, with Mr. Copeland as a witness, with his counsel as a witness, court reporter, transcript. And Judge, I'm not trying to be harmful.
Mr. Steele, I think that you're running a very thin professional responsibility line. I don't think you have cover at this point in time. I think you're blowing your coverage at this point, because I do think that somebody told you some things that violate privilege.
What privilege?
Attorney-client privilege. So, I mean, but that's beside the point at this point in time. We're not gonna argue about that right now. I just need the way you purge your contempt is that you just tell me who told you this. I'm not asking you what was said. But you're indicating what was said. I want to know who told it to you.
And I'm making it based upon information.
But I need to know who it is, because that's critical for the court taking remedial steps at this point in time.
You're holding me in contempt.
No. Yeah, I'm holding you in contempt because you won't tell me who.
How could something, I'm not trying to be obstruction, but how could something be attorney-client privilege if it happened before the court?
Well, because if somebody's a represented party and they disclose the information that to you all as parties in this case, that could be a problem. That could be a problem.
I don't.
I mean, like I said, I don't know what was said to you. I don't. So
I'm trying to get out.
Well, that's improper at this point in time.
Why?
because you are telling the court conversations that you are privy to in my chambers that I know you weren't present.
But the court was present. That's what I'm trying to say.
That doesn't make a difference, but you got information that you shouldn't have had. And then you can't, and then you turn around and you say, well, the court did something wrong and that we should be entitled to have the transcript. You all have contorted and perverted that particular process. You really have.
What I said was it is a material part of the trial.
It's not, well.
Has a right to be at, and I'd like to
It would be just like if you all in the past have had ex parte conversations with the court. And I won't say about for what? You and Mr. Adams and others. That is your right. And that little period or that little conclave of discussion with the court protects you and protects the system. It's recorded and taken down. So if it needs to be reviewed later, it gets reviewed. But you have made something out of it that where I'm kind of at a disadvantage at this point in time. So, because I didn't invite you into that particular proceeding, and I don't think you had a right to be there.
Well, all I know is what I told you, and there's more.
Okay, well.
There's a witness testifying who met with the court and the DAs. That doesn't concern us?
Your Honor,
Meaning the defense?
I think that for an ex parte conversation, in terms of what was said, and I'm not gonna keep continuing to discuss this because the transcript is what the transcript is, and it will say what it reflects. It really will, and the court will stand by that. But the other conversations that you may have privy to or may have been disclosed to you, they're troubling. They are. That's why I've got to find out who it is that disclosed that information. So you have the keys to your own contempt. I don't want to hold you in contempt, sir. I don't. I'm not asking you to tell me what was said between the two of you.
He had so many reasons why he needed to.
Who told you?
That's why I need to get that information.
So if you're willing to tell me that, that's fine. That will purge your contempt. If you don't want to, then, I'll unfortunately have to look at and waiting to get that information. So you can let me know.
Did the court put this in an order?
In terms of what, sir?
I suppose contempt.
It's criminal contempt. It's sua sponte criminal contempt, sir. You don't get to appeal from this. You will go into custody at 5 o'clock today or whenever we finish if you don't tell me what that is. Tell me who that is. This is criminal contempt. I have asked you a question related to this particular proceedings, and if you don't tell me, then you'll suffer the consequences of that. Unfortunately, like I said, I'm not looking to hold you in contempt. I really am. I'm not. But this is that important.
Important. It is important.
Okay. All right. So think about it. All right.
Can I just, last thing, going forward is over objection, because I believe that we're entitled to these information, especially with this witness.
All right, sir. I'll note your objection. It'll be a continuing objection for the time being. And I may make some other remedies depending upon what information I find later. Okay? All right.
On behalf of Mr. Stillwell, I'm going to review
Our Brady demand for any Brady material
Yes, sir.
that came out from any conversations with Mr. Copeland, between Mr. Copeland and the district
Yes, sir.
attorney's office this morning.
All right. Summon our jurors, please. Yeah, bring him out, please.
Look at Brown, y'all.
Okay, that's fine. Some of yours, please.
I'll do the present counsel.
All right, thank you, sir. Ladies and gentlemen, please be seated. All right, Ms. Hilton, go ahead now.
Can you hear me? Can you hear me? Okay. When we left after court, I'm going to approach you with some items. Your Honor, may I approach the witness?
You may have shown those to counsels already.
Yes, these are what they saw right before we took lunch. Mr. Copeland, I'm going to show you what's been marked as State's Exhibit 350Y, 351Y, 342 Yankee, and 356 Yankee. Can you take a moment and look at those pictures? Please look at those pictures.
Do I have to look at them?
Yes. I'm going to start first with State's Exhibit 350 Yankee. Tell me if you recognize individual in State's Exhibit 350 Yankee.
I recognize myself.
Okay. Do you recognize anybody else in 350 Yankee?
Myself.
Do you recognize anyone else in 350 Yankee?
Their face is covered up.
Okay. Do you see someone's face who's not covered up in 350 Yankee?
Yeah.
Okay. Do you recognize who that person is?
I can hardly tell.
Okay. Is that Shannon Jackson? Your Honor, at this point in time, I'm turning to impeachment.
Oral, sir.
I'm also going to object to showing the witness altered photographs.
Your Honor, it's based upon the court's previous rulings.
Not based upon it's not.
Let me see it. I see it, please.
We've never discussed these photographs.
Chris, do we have 350?
As well, if you want to see the original.
Has 350 been admitted already? Okay, all right. Oh, you just so you're just showing him at this point in time? It's not been admitted, Ms. Hilton?
It has not been
Okay, all right. You have any further objections, sir? What's your objection to? No, that's not an objection. What's the basis for your objection, sir? Do you have an objection as to the photo itself? Huh?
Not as evidence, it's improper to show that photograph of the witness.
Your Honor, I'm not sure what Mr. Shar is calling altered. The only thing that has changed is based upon previous objections.
Oh, y'all want to come up? Excuse me.
I'm going to show what I'm now going to mark as 342 Yankee Oscar for original. Mr. Shard, do you want to come and see these? What is your objection? Hold on, I'm now gonna show you what's gonna be 356 Yankee Oscar, 342 Yankee Oscar, 350 Yankee Oscar, and 351. Are those the same pictures that you just looked at? For the most part, you shake your head. You just got to say yes or no for the record for me.
Yeah.
Okay. Now we were at 342 Yankee, right? No, we were at 350 Yankee. Besides yourself, just tell me everybody else you recognize in 350 Yankee.
You said show you what?
Besides yourself, tell me everyone else you recognize in 350 Yankees.
But you might name the people that's in the photo?
Yes, sir.
Me, Shannon, DB.
Do you know the fourth person?
I can't really tell their face.
Okay. Does that appear to be a fair, accurate depiction? So does that look like you, Shannon, and DB back in 2014? 2013, excuse me.
Objection to the timing. I'll sustain the objection. You can rephrase me.
Does that have a date on when this picture was posted to Instagram on there?
What you mean?
Does it have a date down here? Can you see that?
I can't see that.
Okay. But does that look like the three of you, DB and Shannon? Does it look like y'all?
I just said yeah.
Okay. Your Honor, this time the state would like to tender State's Exhibit 350 Yankee into evidence. 350 Yankee Oscar into evidence.
Any objection to states 350 Yankee Oscar? Hearing none, it's admitted, maybe published as you see fit.
Thank you. Now looking at 351 Yankee Oscar, do you recognize anybody in 351 Yankee Oscar? Who do you?
What?
Do you recognize anybody in 351 Yankee Oscar?
What you mean?
Do you recognize anybody in that picture?
Yeah, the same three.
Okay, so you, Shannon, DB?
Yeah.
All right. And does that look like the three of you back whenever you all took those pictures?
It's my first time seeing this picture.
Okay, but is that y'all in the picture? Yes. Your Honor, this time the state would like to tender 351 Yankee into evidence.
Any objection to state 351, is it Yankee or Yankee Oscar?
Thank you, Your Honor. Yankee Oscar.
On that, I was looking for, yes, you have objections.
We're going to not publish that version. We're going to get,
Okay.
we acknowledge what his objection is and we have corrected it before we published it.
You want to show it to him?
If he can come over to Ms. Knight. Just okay. Your Honor, state moves to tender State's Exhibit 351 Yankee Oscar.
Any further objection to states 351 Yankee Oscar?
No, Your Honor.
All right, it's admitted, maybe published as you see fit.
Next, Mr. Copeland, I want you to look at State's Exhibit 342 Yankee Oscar. Tell me if you recognize anybody in State's Exhibit 342 Yankee Oscar.
But this one?
Yes, sir.
It's blurry.
Okay, do you recognize anybody in that picture, although blurry?
I can tell this me, but I can't really tell who the other people are.
When you say it's blurry, can you see anybody else on there, or you can't recognize no one?
No, I could see, but I can't really see their face like that.
Okay. Looking at 356 Yankee Oscar. Do you recognize 356 Yankee Oscar?
It looked like me.
Is there anyone else in there that you recognize?
It most definitely me. I can't really tell who they did with me though.
Is that Shannon Jackson? Or Shannon Stillwell?
Nah, they dude got a mustache.
Okay, so is this your testimony that is not Shannon Jackson in this picture?
All I can say, I can recognize me, but I never seen that picture before, and I don't want to say that's him if it ain't him.
Okay. You are permission to publish 350 Yankee Oscar and 351 Yankee Oscar.
Yes, go ahead.
Now, first looking at 350 Yankee, are you able to tell us which one described by clothing? Where are you?
What you mean?
Which one of these individuals did you?
Which one on what?
Which point to you in that picture?
With the hat on.
Okay, there's 3 people with hats on. Which person are you with the hat on?
With the writing on my shirt.
Okay, what does the writing say?
DRC, third YRC.
What does DRC mean?
DRC.
What does it stand for something?
You asked me what it means, DRC.
Okay, does DRC stand for something?
Not to my knowledge.
Okay, it doesn't stand for the robbing crew.
I'm not a rob.
Hold on.
Okay, that's fine. I'm asking you what does it
Hold on. I sustain objection as to form. You can rephrase.
What does YRC stand for?
YRC.
Yes.
This stuff don't have no meaning. This how I got this shirt.
Okay, that's your testimony today. That neither DRC or YRC mean anything.
That's how I got the shirt.
Okay, I understand that. I'm asking you, is this your testimony that DRC nor YRC mean anything?
I'll rule the objection.
Is that your testimony? That doesn't mean anything.
I said this how I got the shirt. So the shirt didn't have no meaning to it.
Okay. Who else do you recognize in that picture?
I just told you, me and DB.
Right. I saw it. The jury did not see.
Oh,
So I need you.
my bad.
Okay. So which one is DB?
He died.
And I'm sorry to hear that. Can you tell me who he is in the picture though?
What you mean?
Just tell the jury, what is he wearing in the picture?
I can't really see what he got on.
Is he the one in the green hat or the one in the purple or the one in the blue New York Yankees cap?
You said green?
Is he the one with the green,
Okay,
greenish hat?
I just didn't know the color.
Okay, so he's the one with the, like behind you a little bit.
You standing behind me?
Yeah.
Yeah.
Okay. And then you said you recognize Shannon in this picture. Where's Shannon?
With the blue on.
With the blue hat on, the New York Yankees cap?
If that what it is, I guess.
Okay. All right. Thank you. And are you able to see on there the date of that picture or is that blurry for you?
No, I can't see.
Okay. Looking at that picture, can you tell me about how old you were in that picture?
You look like I was in elementary school.
All right. But is it fair to say that it wasn't within the last 3 to 5 years?
Huh?
Was it within the last 3 to 5 years?
I've been in jail.
Okay. So it's fair to say it was before that. I just need you to answer for the record.
I've been in jail for the last 3 to 5 years.
Okay. So it was before that. This is yes or no.
I don't even know which one to say yes or no to.
Okay.
If I
What-
say yes, I'm saying yes to it.
The picture was before 3 to 4 years ago.
The picture when I was younger.
Okay. Next, can we please publish State's Exhibit 351 Yankee Oscar? Now, I think before you said those were the same 3 people in 351 Yankee Oscar. Is that you on the left with your hands up and you have on the shorts?
I'm standing to DB right,
Okay. So that's to my left?
I think.
All right. And then is that DB in the middle?
DB in the middle.
And is that Shannon to the right or to my right?
It looked like Shannon.
Okay. And again, about how old were you when you took this picture?
I don't know.
But it's fair to say that you were younger than you are today.
Say that again.
It's fair to say you were younger than you are today.
Yeah.
Okay. Do you think it was around the same time you took the other picture that we just looked at?
I can't say when.
Okay. All right. Thank you so much. Now, we spoke about your relationship with Shannon. As your friendship developed, did you all share personal information with each other?
What you consider personal information?
Did you talk to him about your secrets? Did you confide in him about life, things that had happened?
Now, my seat go to the grave with me.
Okay. Were you someone, did you consider him like a brother to you?
Still do.
You still do? Now, outside of you and Shannon, did you all have another friend that you spent a lot of time with?
Meaning?
Is there any other person that the two of you collectively spent time with?
It's my all 3 of us together.
Yes.
A lot of time together. I don't know about it.
Okay. Is there someone that you spent time together with Shannon?
I spent time with Shannon with a lot of people.
Okay. Let me ask you this. You just said that Shannon, you still consider him like a brother to you. Is your relationship the same today as it was, say, back in those pictures?
Say that again.
Is your relationship the same with Shannon today as it was back when we were looking at those pictures?
No.
How has your relationship changed?
It's better.
It's better now? Why do you say it's better?
What you mean?
You saying it's better?
I barely knew him.
Is your relationship with Shannon the same today as it was back in 2014?
I can recall 2014. I've been in jail so much.
All right. Do you know someone by the name of Demekion Garlington?
Street name.
Little D.
For sure.
How do you know Little D?
I didn't birth him.
I'm sorry, say that again.
I almost birthed him.
You almost birthed him?
Yeah.
Tell the jury, what do you mean by that?
That mean he my son.
Okay. And let me ask you this. Do you know another person who's referenced as Little D?
What you mean?
Do you know someone who's called Little D from Cleveland?
Oh, I heard of him.
You heard of him. Okay, we'll talk about him in a moment. Now, the Little D that you said is like your son, is that what you said? How did you all first meet?
What you mean?
How did y'all meet? You say he like your
I
son.
don't know how we meet.
You don't know how y'all met?
No, I don't recall how me and him first meet.
Okay. How long have you known him? And if you're 32 now, just
I knew him a long time. I knew him longer than Shannon.
Okay. Did y'all grow up in the same neighborhood?
Probably, but we never hung.
How old do you think you were when you started hanging with Lil D?
I don't know.
If we're in 2024 now, did you start hanging with him when you were elementary school, middle school, or high school
I
age?
don't remember.
Don't remember.
I know when DB died, this when I took him in.
Do you remember what year DB died?
I don't remember when DB died.
Do you know what section of the city Demekian is from?
No, I do not.
Did you all ever attend school together?
No, I can't go to school with my son.
Okay. Well, when you say it's your son, how old is Demekian? If you 32, how old is he?
I don't know. I don't know.
Is he close to aging for you?
What you mean?
Is he close in age to you?
He probably about 10 years younger than me. I don't know.
So you say Lil D is about 22 right now?
I don't know.
You say he's like your son. How often would you spend time with Lil D?
What you mean?
How often did you see Lil D? Back in, say, 2014, 2015?
I used to see him around.
Okay. How often?
I can't say.
You can't say? All right. Did you speak with him over the phone? Did you speak with him on the phone?
Speak who over the phone?
Lil D.
When?
At any time?
Yeah.
Since you've known him? How often would you speak with him on the phone?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whenever I felt like it.
Okay. So was that every day? Was that once a week?
Whole time.
And I understand until you answer the question, I'm gonna have to ask you again. So was that every day? Was that weekly? Was that monthly? What was it?
I don't know.
I'll go back in a week. How often would you see him?
What you mean? When are you talking about?
Back in about 2013, 2014, 2013 to 2015.
Well, yeah, he stayed with me.
Okay. When did y'all live together?
He didn't really stay with me, but he stayed at my residence.
Okay. Were you staying at the residence at the same time?
But I was in jail, so.
Okay. So while you were in jail, he was living where you live. Prior to you going to jail, which you went to jail in 2015, that fair?
I went to jail 2012, 2013, 2014, 2015, stayed in at 2019.
Okay. When you went to jail before 2015, were you in and out of jail?
When I went 20 wedding?
In 2012.
2012.
How long did you stay in jail?
I got out 2013.
Okay. Did you go back to jail in 2013?
I got at the end of the year. I went back 2014.
All right. And then between 2014, did you get out of jail in 2014? Is that a yes?
Yeah, I got out.
And then did you go back to jail in 2015?
2014. I went to jail like a couple times 2014.
Okay. So you were in and out.
Right.
And then in 2015, did you go back into jail?
Yeah.
And is that where you spent the long duration?
I went to jail a couple times in 2015. But the last time I stayed until 2019.
Okay. And it was the last time that you went to jail in 2015, June of 2015.
That was the last time, yeah.
Okay. And so prior to June of 2015, you were in and out that year between January and June.
Right.
Okay. In the periods that you were not in jail, did you and Lil D ever live with each other when you were not in jail?
In 2015?
We'll start in 2015, yes.
Nah, he ain't stayed with me in 2015.
Okay. In 2014, those times that you were not in jail, did Little D stay
Right.
with you? And then what about 2013? The times that you were not in jail, did you and Little D reside with each other?
What you mean?
Did y'all stay with each other and did he stay at your home at any time in 2013 when you were not in jail?
2013, when I started to get to know him.
Now, you said that he's kind of like your son. Did you all share things with each other? I'm talking about conversations, personal conversations between you and him, and vice versa.
Not no secrets.
Okay. But did you feel comfortable speaking to him? You did not?
Nah.
Okay.
I didn't feel, I didn't feel, I don't know what you mean. Like, I didn't not feel comfortable. I didn't feel like some stuff we just don't talk about.
That's fair. Did you consider Little D like your brother? I know you call him your son, but did you consider him like a brother?
I consider him my son.
Okay. Do you recall ever telling any detectives previously that he's like a brother to you?
I probably did. I ain't no telling.
Okay. Yeah, permission to approach?
Have you shown that to the defense counsels already?
Yes. Well, no.
Just make sure you show it to them.
I will.
Yes, court was over at 9:45 a.m.
Permission to approach, Your Honor?
You may, madam.
Mr. Copeland, I'm showing you what's been marked as State's Exhibit 358 Yankee and 380 Yankee. Starting with 358 Yankee, do you recognize anyone in State's Exhibit 358 Yankee?
Yeah, me and my son.
Okay, is that the person that you've been referencing as Little D?
Yeah.
All right. And looking at 380 Yankee, do you recognize the individuals in State's Exhibit 380 Yankee?
You said what now?
Tell me who you recognize in 380 Yankee.
Oh, me and Coco.
Who's Coco?
The ugly boy right here.
Okay. Do you see the person that you said is your son, Little D, in that picture?
The restaurant got their head down.
Okay. Your Honor, this time the state would like to tender State's Exhibit 380 Yankee and 358 Yankee into evidence.
You said 380 Yankee
Yes, Your Honor.
and what else?
358 Yankee.
Any objection to states 380 Yankee or 358 Yankee?
Yes, Your Honor, that foundation, 380 as well as hearsay included on 380.
What about 358? All right, 358's admitted. Let me see 380, please.
And I can lay a little bit more foundation for 380 Yankees.
All right.
As far as the hearsay.
Okay, then go ahead.
Mr. Copeland, have you previously had an Instagram account?
Say that again?
Have you had an Instagram account?
Yeah,
And how many Instagram accounts have you had?
I don't know.
Okay. How many different names of Instagrams have you had?
2.
2. Okay. Has one of your accounts been 372 Woody?
I can't recall.
You can't recall. Okay. Are you Woody? That's what they call you, right?
For sure.
All right. And do you know any other Woody who hangs with you? Is there anybody else in your friend group that they call Woody?
Yeah.
Oh, how many other Woodies are there?
Jamie and the other one.
Okay. What's the other one's real name?
He died too. I don't know his real name. I think it's damn. I know his last name Bridges.
Looking at that picture, is the other Woody in that picture?
I can't tell because the other guys got their head down.
Okay, well, just look and see if you see someone who looked like the other Woody, even with their heads down.
Can you show me a clear picture?
When you say clear, what's not clear?
Because he got his head down, he got his head down, my hand covering his face.
Let me ask you this, when did the other Woody pass away?
Right before I got the feds.
Mechanicsville, Lil D.
When you say right before, meaning that year, a few months, what do you mean?
I got it like September and somebody killed him, like probably, I don't know when, but they killed him before I got out.
Before you got out, okay. All right. Looking at State's Exhibit 380 Yankee and looking at that picture with the 372 Woody, is that from your Instagram?
You talking about the one with all these people in it?
Yes, sir.
Okay.
Is that from your Instagram?
I don't recall this Instagram. My Instagram is Woody versus Woody.
Is that your newest one?
What you mean?
Is that the one that you currently have right now?
No, the one I currently have now is Woody _ self-made.
Okay. So are you saying you don't know if that's your Instagram?
I don't recall this Instagram.
You don't recall that Instagram? Okay. You're right.
If it's mine or not, I don't know nothing about it.
But do you see yourself in this picture?
Which picture?
The picture that's posted on this.
Yeah, I'm sitting right there, ain't it?
All right. And right here, you can't tell if you see the other Woody.
I can't. I can see me and him real clear. Both of us got our heads up.
All right. Your Honor, again, state will still like to tender State's Exhibit 380 Yankee for evidence.
Let me see it, please. All right, any further objection to 3D Yankee, sir?
I don't actually, I'm gonna draw my objection to that foundation. I do continue my objection as hearsay. The foundation is not made to establish the declarant, and also regardless of who the declarant is, it's not a court statement that would be hearsay that doesn't fall under these.
We all approach, please.
Published once it's submitted with the court's ruling.
Mr. Shard, any further objection to states?
I'm sorry, I didn't. 380?
Yeah, 380 Yankee.
No, no, nothing further.
All right, this is good.
All right.
If you publish it, just-
First, we're gonna publish 358 Yankee. And looking at 358 Yankee, can you tell the jury, or tell the jury which of the two of you is little d, or who you call your son? Which one? The person to the left of you, right of you?
What you mean?
Is that little d to my right?
This little D in the picture with me.
Okay. And do you know about how long ago you took this picture?
No, I don't.
And we keep saying little d or your son. Do you know his given name? His real name?
No.
Do you know his real first name?
You said you make young got it.
Okay. And is that the person that you know is little d?
This little D right here in the picture with me.
And is that Demekion Garlington?
This little D right here.
Is that Demekion Garlington?
If this was your name, then yes.
Now showing you 380 Yankee. Can you zoom in to the picture? Now looking at 380 Yankee, is that you sitting on the step in a white t-shirt and blue jeans and black and gray sneakers?
Yes.
Okay. And who's the other person you said that you knew in this picture?
The ugly boy right here.
Okay. And what is that? What is the individual that you pointed to? What's their name?
Coco.
All right. And in this picture, the person behind you with the 30 deep B. I think it's BITXH shirt on. Do you know who that is?
I can't recall who that is.
You cannot recall. Does that look like Demekion or Little D? Does that look like Little D?
The head cut off.
Okay. If you could, can you turn your chair around and look behind you?
What about it?
Does that look like Little D?
I guess.
Okay. Well, is someone you call your son? Does it look like the person you know
I
to be
can't
your
see
son?
that far. I just told you that from the beginning.
Okay. All right. What, if anything, are you doing with your hands in this picture?
I'm doing nothing with my hand.
Okay. I want to go back to 358 Yankee. What, if anything, are you doing with your hands in 358 Yankee?
What you mean?
What, if anything, does what you're doing with your hands symbolize, if anything?
A bird.
Okay. Does it mean anything specific?
No, throwing up a bird.
Why are you throwing up a bird in this picture?
Because I'm from Mechanicsville.
Is that the symbol for Mechanicsville?
We represent a bird.
Okay. And then what about Demekion? Are you familiar with the hand gesture that he's using?
Say that again.
Are you familiar with the hand gesture that Demekion is using? And no,
Now, I don't know what that for to mean.
you don't. Okay. How is your relationship with Little D today?
Meaning?
Do y'all still have the same relationship that you had back in, say, 2015?
No, we don't.
How has it changed?
I wanted him to lie for me and he wouldn't.
Okay. And when was that?
back in the day.
When you say back in the day, what do you mean?
When the police was accusing me for stuff, I went to Lil D and told him what I wanted him to tell the police. And he went to tell the police that, so I got mad at him.
Okay. And what year are we talking about that this occurred?
I don't know.
Are you speaking about one specific occasion or just multiple times?
No, I'm talking about one specific occasion, however you pronounce it.
And is your testimony that you have not been friends with him since that time?
Now, I have spoken with him, but our friendship ain't been the same.
When you think about your friendship with Demikian and your friendship with Shannon, at this point, who are you closer to, Shannon or Demikian?
Myself.
Okay. But outside of those, I'm speaking specifically about those two individuals, between Shannon and Demikian, at this point, who, if either of them, are you closer to?
I don't understand what you're trying to say.
You and Demikian that's like your son, right?
Right.
And you said that the two of you, Your Honor, I'm just trying to clarify for Mr. Copeland.
I'll sustain the objection. You can sue it, please.
You consider Demikian like a son. Is that fair?
Same objection. I'll sustain the objection.
Who are you closer to today? Demikian, Shannon, or neither one of them?
God.
Okay. That's good that you're close to God, but I'm talking about Demikian, Shannon. Who are you closer to today? Demikian, Shannon, or none of them, or neither of them?
I guess neither. I don't know how to answer that.
Back in 2013, 2014, 2015, that's the time frame we're talking about. How close was the relationship between you, Shannon, and Little D?
It was difficult.
You said it was difficult?
Right.
How was it difficult?
You just put 3 years together. So a lot happened within 3 years.
So let's first start with 2013. Describe for the jury your relationship with Demikian, Shannon, and Little D. Let's start with 2013. Tell the jury about your friendship and relationship with those two young men back
As in what?
Were you three of you close? Were you not close? Tell the jury about your friendship.
Look, I took special ed classes. You got to talk to me in a way that I can understand.
Sure. Back in 2013, were you friends with both Little D and Shannon?
Yes.
Okay. How close were the three of you back in 2013?
Again, my friend was killed. That's when I started embracing Little D.
All right.
In 2013.
When you started embracing Little D, were you and Shannon friends at that time?
Me and Shannon was friends, but me and Shannon was not together on the street as much as friends. We was not together a lot.
Okay. When did you, Little D, and Shannon start hanging together a lot?
20.
Did you, Shannon, and Little D hang out together?
Yes.
When did the three of you start hanging around each other?
The longest I've been out of jail was 2014.
To your knowledge, did Little D and Shannon, strike that. How did the three of you all start hanging out together?
I don't know.
Did you introduce Little D to Shannon?
No,
Did you introduce Shannon to Little D?
no,
Okay. Did Little D and Shannon know each other before they knew you?
I state objection.
Do you know if they knew each other before they knew you?
I don't know.
You don't know.
I don't recall how it started. I just know I started embracing DB, Lil D after DB got killed. Lil D was more a DB friend.
After DB passed, you embraced Little D. Did the two of you start hanging out with Shannon after that?
I just said, how could I say this? Me and Shannon wasn't together in so long to be on the street. So I don't know when our three of us was able to get together. I just know at one point we used to go to the club together.
Did y'all do anything else besides go to the club together?
Yeah.
What?
Objection, Your Honor, may we approach? Sure.
So we said that you all would hang out. Did you all spend time at each other's homes?
No.
Okay. Did you all spend the time at other people's houses together?
What you mean?
Like, did you all go to other people's houses and spend time at other people's houses together?
We didn't spend time at people's houses, but we don't been to, we go to people's houses.
Okay. You said you went to the club. Would you all go out to eat together?
Yeah.
Okay. Did the three of you go on any vacations together?
No, we don't do vacations.
Okay. Did y'all ever take any trips out of town together?
Not that I recall.
Were you familiar with any of Demikion's family? His mom, his
I know his
cousins?
mom.
What about Shannon? Did you know his grandmother or any of his other family members?
No, I didn't.
You have children. Did they have any type of relationship with your children, Little D or Shannon?
No.
Okay.
Not that I know of.
All right. What about you? Did you ever spend time? Let me back up. Did Little D have children?
Ain't no telling.
Okay. To your knowledge, does Little D have children?
Not to my knowledge.
All right. To your knowledge, does Shannon have children?
I think so.
Okay. Have you spent time?
Well, Shannon have children.
Yeah. Have you spent time with his children?
I have.
Okay. Have you taken them to birthday parties?
But my relationship with his children is not through him.
Okay. Who's it through? Their mother?
Yeah.
Okay. No permission to approach.
You show that to the defense counsel?
Show it to them now, Your Honor. You have to look at this one. This one. Mr. Copeland, I want to show you what's been marked as State's Exhibit 355 Yankee. 357 Yankee. 345 Yankee. 346 Yankee. 359 Yankee. And 374 Yankee. First, I'm going to start with 345 Yankee. Can you tell me if you recognize anybody in State's Exhibit 345 Yankee?
I can't recognize nobody in 345.
Do you see yourself in 345 Yankee?
The picture blurry. I can't recognize nobody in the picture.
Okay. Have it blown up. Okay. We'll come back to 345 Yankee. I'm now showing you what's been marked as State's Exhibit 346 Yankee. Tell me if you recognize Exhibit 346 Yankee.
Okay, guys. So I am going to lunch. I will be pausing the live. I'll let you guys know if I'm coming back. We were just replaying stuff because we didn't have court, but keep your notifications on. Make sure you like and subscribe the live, and I'll probably see y'all on Monday. I think. Yeah, Monday. All right, bye guys. Thank you for staying on with me today.